Ladies and gentlemen, welcome in here. Thanksgiving Sunday, Murder Church edition happening right now. I hope everyone had a good holiday and a good weekend. Getting ready to start another week as we head forward to Christmas. It feels like just one big holiday, really, but here we are. We're going to be continuing down the road here in our current trial, Aileen Wuornos. Today, at least we're starting out today with counsel and the judge discuss evidence and testimony outside the presence of the jury. That's where we're going to start off. Welcome in. Give it a like. Give it a share. Let's go over some stuff. Welcome in.
I get my hair out of my face while I'm doing this.
Proceedings are now
putting somebody who was raped.
Let's rock.
Boom. Good morning, beautiful people of YouTube and the world. Welcome in, welcome in. We've made it, just like I just said, to another Sunday morning. I'm excited. Through another weekend, through another holiday weekend even. So, we got a lot of cool stuff going on today, per usual on a Sunday. I usually stay pretty busy on a Sunday. One thing that I want to say, we're starting off first of all with Aileen, of course. We'll be here for a few hours. But today at 4:45 Eastern over on Russell Plunge, I got a brand new video dropping. And for anybody that does not know, that is how you get on a special wheel where you can win a free t-shirt, including the brand new Pit Crew shirt that has just been released on publiclybuzz.com. But what you have to do is you have to go to the brand new video that drops today, again, 4:45 Eastern on Russell Plunge. You got to go to the video, give it a like, give it a comment, and watch the video to completion. And if you have the option to leave some hype, please leave some hype on it as well. If we can get that thing tracking into the algorithm, oh my God. Last time we ended up with 37,000 views on my last video. We just got to get in front of the right eyes, and yeah, you guys help me out, and we'll get a wheel going, and I will give away a free t-shirt. Other than that, of course, I go live on Sunday nights on Russell Plunge also at 6 Eastern. But let's see what we got in the chat here this morning from Murder Church. Nosy Rosie. Hold on, let me get the chat working. That'll be a good start. That'd be a great start, Steve. Boom! Nosy Rosie. Kathy, I just got your message also through Big Cartel with your address there in chat. Won a wheel last week. Pumpkin won that wheel. Good morning to you and Pumpkin. Bassett Page hanging out. Just a crazy gin popping through this morning. Love to see it. Love to see it. Carrie popping through. Boom, boom. Sharon. Welcome in, Sharon. Appreciate it. I don't think I'm missing anybody. Amanda coming through this morning. Awesome. Well, yeah, we're going to start out right now. Again, outside the presence of the jury, judge and, counsel and judge discuss evidence. Let's get it. See how far we get this morning. Keep on rocking and rolling. Aileen Wuornos, 1992 trial. Get the sound in here. Boom. Let's go.
Order signing that needed to be done for tomorrow, Sunday. I believe that.
My God, I forgot what I said last week. The dude looks like from Weird fucking Science. Oh my God, dude, he looks like the thing from Weird Science.
Defense counsel might have some objections on the proposed order, and I remain rejected.
We gotta grab this and pop up.
Actually, we dealt by agreement of the parties with a number of matters off the record with Your Honor yesterday. One of the matters that pertains to an order before the court today is the order appointing Dr. Bordini in the case. We would formally enter an objection to both the appointment and the scope of the examination. We do not think that there is any rule that covers such a procedure. Some of the objections are similar to those previously raised with regard to Dr. Barnard. In addition, we would specifically object to subsection 2 of the order, paragraph 2, as involving an improper manner this time, since the defense has neither opened the door nor is there a provision allowing for such an examination.
Mr. Tanner,
If Your Honor, please, our request of the appointment is based upon laws and procedures recognized by the court in their response to anticipated defenses, either of a mental condition, mitigation at the penalty phase, or perhaps even with regard to diminished mental capacity at the guilt phase, if the court would allow such testimony, which has never previously been allowed in the courts of the state of Florida, but I think we need to be prepared for that. We believe we stand on case law well grounded legally, Your Honor.
Yes, no.
I'm sorry, Your Honor.
Any further?
We would just object on 5th and 6th and 8th Amendment grounds, Your Honor.
The order has been signed. Copies will be furnished to the sheriff for transportation for tomorrow. So, I think you exchanged telephone numbers so that counsel can contact in the event of any emergencies.
We've done that, Your Honor. For the record, Your Honor is also entering at this time an order appointing Dr. Kropp, and as the order relates, Ms. Wuornos will be available to Dr. Kropp on Sunday, depending on when Dr. Bordini finishes his examination, or given that the parties have no problem with it, the two doctors might be able to see her at the same time. One of the other matters, Your Honor, as I indicated, we took up a number of matters with the court yesterday. There was one thing that I think we need to formally object to on the record. At one point in the proceedings, as Your Honor saw, some of the objections were getting rather heated, and Your Honor commented, I don't remember the exact words, but something about the record is, the objections are stated for the record for when the case goes to the Supreme Court, or something. I don't remember the words Your Honor used. We would formally object to the comment and move for a mistrial. Thank you, Your Honor.
No one's getting a mistrial.
I thought the jury was here, Judge, but the record will reflect that one way or the other. Oh, Judge, and I think Mr. Tanner has no problem with this. We would also request copies of any notes and testing materials from either Dr. Bordini or Dr. Barnard. Dr. Barnard will not have testing materials since he's a psychiatrist, but he will have notes, and Dr. Bordini will have both notes and testing materials.
Allergies are messing with me this morning.
Those materials be provided to Dr. McMahon, Dr. Kropp, and Dr. Toomer.
Well, I have an idea we'll go through the same games there that we went through with Dr. Toomer, Dr. McMahon, so we can play those games.
Including
the
any...
same degree of cooperation as we exerted.
Oh, God.
I'm sure that
Including any other documents, Your Honor. Those all go to those three experts, Dr. Toomer, Dr. McMahon, and Dr. Kropp.
Your Honor, please, Court, in reference, going back to the mental health care experts, Mr. Nolis is, and of course I realize that he has a record to protect defending in a capital case, but he's indicated some objection based upon the appointment of Dr. Bordini, our psychologist, and at the same time, orally this morning, and I think it was mentioned yesterday for the first time that I recall, it certainly this morning, on oral motion, the court granted Mr. Nolis' request for an additional psychologist, Dr. Perry Kropp.
Do you feel that's the first health expert appointed in this circuit, in this court, for this case?
Yes, sir.
The others are not appointed by this court.
I'm getting to Dr. Harry Kropp because my concern is we have not received Dr. Kropp's test reports or results.
Not to interrupt you, Judge. He hasn't seen Ms. Wuornos yet. He was just appointed and this morning, Your Honor, entered the order, and that's what we're trying to arrange for this week.
And if, in fact, Dr. Kropp is going to do any testing or make any notes or accumulate any materials on which his opinion is based, we would like reciprocity assured to us by defense counsel that in return for us instructing and directing, in fact, may we have an oral order from the court, if we can stipulate to it, that Dr. Bordini be instructed by counsel, me, or my representative, to turn all such materials or copies thereof over to the defense either their expert or the lawyers themselves, whichever they choose, and that in return, Your Honor, instruct the defense to instruct their psychologist, Dr. Kropp now, to turn over any materials, notes, or reports, and then be continuing as these materials are generated. We now understand Dr. McMahon is going to talk to her again. This be a continuing order throughout the rest of this trial, because we don't have time, Judge, to come in here and ask for a court order every time they refuse to obey a subpoena. So may we have a court-directed accommodation, which apparently we've been able to reach at this point.
Judge, very simply, you know our position.
I didn't even realize I was muted. Thank you very much. Got the judge meme in place, though. The turd monster is what I think that dude's actually called. The turd monster is what the judge is going to be referred to as now. The Chet monster. Hell yeah, that's what I'm talking about right there. Wearing my Meowner Church shirt this AM and babysitting my niece and nephew. They love the cat. That's awesome. That was a very fun shirt. Again, props to Tao Toys. He created that image.
Position is that the testing materials should not go to lay people. Your Honor has already indicated a ruling, and we've objected. We can renew all of that argument and objection with regard to Dr.
That's what I
Kropp.
want to avoid.
Morning,
That's
Tina.
what I want is spirit of cooperation. It would be a new experience here.
That's where I was going, Judge. For the record, we would renew those arguments. I assume Your Honor will issue the same order.
It's not your intention to cooperate.
No, it is. I'm saying for the record, and I assume Your Honor will order us to cooperate.
That's right.
Okay? Reserving the objection, we'll work it all out. That's all I'm saying, Judge.
I would think that those things can be raised without court order, but if you feel like it's necessary, it's so ordered.
Thank you.
And we'll work. Remember, Judge, what we're doing is we're reserving a technical issue relating to the testing materials. I don't want to, after the arguments you present to the court, I don't want to stand up here and say, oh, no problem, what we do. But I just, with reserving that, I can assure the court we'll work it all out.
And the order has now been entered directing us
To work it out.
tell our mental health care experts there's a standing order of this court that they are to freely exchange between themselves and counsel of record on both sides all such materials, notes, and records. Correct?
Yes. And in fact, Judge, we will contact all of the experts and relay that to them, and Mr. Tanner can contact, I think there's 5 experts in the case. Why don't we have both sides contact everyone and tell them the same thing, and
Good.
we'll get there.
That's fine. All right, now, we would argue then motions in regard to similar fact testimony I'm prepared to proceed.
I guess the first question, Your Honor, is what the state's position is. The state has to...
That's the reason I said I'm ready to proceed. I don't know what they want to do.
Look at this shot right here. I wonder if I can get the turd monster set up in there. Oh, wait. Too far. He went too far. He disappeared into the ether. There we go. There we go. There, that's perfect. Look at that.
Dr. Please report.
Oh, he's moving. He's on the move.
We have filed in advance of this trial, pursuant to the rules of procedure, notices specifying what evidence we expect will show in the way of similar fact evidence. Judge, those notices to defense counsel in the way of Williams rule establish that this defendant, in a period of approximately 1 year, murdered 7 men within the state of Florida. Those murders are interconnected, Judge, in a number of ways, which I'd like to explain to the court by the use of the chart. In addition to that, Judge, we expect that the testimony will establish in these cases the specific intent of Aileen Wuornos to kill Richard Mallory on December 1st of 1989. With the court's permission, what we would like to do is to lay out some of the evidence that would be established by these cases and show you the similarities and the characteristics between them to establish their relevancy.
See?
Your Honor, let me just indicate, we have no problem if Mr. Tanner would like to do this by way of an opening statement type of thing. However, and I'll go through the case law with Your Honor in a moment, the connection of the accused to similar fact evidence and the fact that the evidence is something that happened and that is relevant to the material has to be established by the state by proof through clear and convincing evidence before the evidence is admitted. And so we're going to have certain issues regarding the proffer that the state is making, and certain issues relating to the witness's rights to cross-examine on those issues.
Hell yeah, Jen. Thank you very much for that. Just a crazy Jen coming through, representing the Jen Nation here in the Buzz Nation. Giving out a membership this morning, and Scarlet Bagpipes is going to pick that son of a bitch up. Hell yeah, Scarlet. Well, you also have the opportunity to join us on Tuesday nights for book club, immediately following our regular scheduled programming at 8 Eastern, usually from 9 to 9:30 or so. Maybe even into 10, we'll go live with the book club, and we're currently reading Mindhunter. So, extremely exciting. Hell yes, Jen, thank you very much for that. And you got On the Wheel, Jen. Thank you very much. And again, for anybody that hasn't seen the new t-shirt, go and check out publiclybuzz.com. Brand new Pit Crew shirt in there that's pretty freaking dank, if I may say. And I've been selling a lot of those. Those are really cool. Thank you all so much, too, for all the support.
Cross-examine any witnesses called.
Judge of the court, please. Judge, the chart before the court, which the state will ask to be marked as an exhibit as we begin the record, will establish that on December the 13th.
Your Honor, not with all due respect, not to interrupt Mr. Damore, but as Your Honor knows, the three defense counsels sitting before you also represent Ms. Wuornos in other cases in other counties, and we would respectfully request that such chart be not provided in a public forum with other trials that are going to take place, and that juries in other counties not be prejudiced by this presentation this morning. All you got to do is turn it to the court, because it's the court that's going to rule on it. You don't have to turn it the other way.
Judge, I'll place the podium wherever the court wishes to be. I can assure the court that the state of Florida will cooperate with each agency within it to see this woman's conviction.
Turn it toward me then.
Let's see that.
This is the same as the exhibit filed by the state and
Yes, sir.
Judge, let me make this inquiry. You're the ultimate, your ruling will be the ultimate ruling on this issue. Since you got a copy in writing like we do, why do we need the big chart?
I don't know if you can ask a question.
Can we just argue since we're all looking at the same thing? We don't need this cute little thing here.
What Mr. Nolas wants the court to do, like try to get the jury to do, is look at this thing in a vacuum.
On X, Sharon, thank you so much for the share this twice this morning, actually. I really appreciate the hell out of that. That's awesome.
And not understand the full context.
Is Mr. Damore indicating that Your Honor cannot follow a printed chart unless you have a big one in front of you?
Yeah, he said to the jury at least.
Bogus argument on the part of counsel.
Objection, bogus argument, Your Honor, and let the record reflect that Mr. Damore has
I don't
not.
need all this comment.
Yes, Judge.
Let's just get serious for a second.
What we see here, Judge, is evidenced by this, is that the dates that the bodies of each of these men was found. You also established that each of the men that was murdered by Ms. Wuornos was a white male, and the age group standing from 39 to as high as 65. Each of the men, as you can see, Judge, following the chart, were traveling on the interstate highway. Each was traveling alone.
Tell me they're not the fucking same thing. Tell me they're not the same. You would be lying to yourself.
And each picked up Ms. Wuornos while hitchhiking by her own admission. Each had multiple gunshot wounds to their torsos, with the exception of Mr. Sims, who the defendant has admitted to murdering and dumping his body in a location which has not yet been found. Each was found in an isolated area. On each of the victims, personal identification of property was taken. That is established by way of the confession of Ms. Wuornos, as well as the physical evidence that is found at the scenes for each of the bodies where each of these men are located. In the instance where the murder weapon can be established, it is established that a .22 caliber revolver was used to kill each and every one of these men. That particular revolver, Your Honor, was loaded with .22 caliber bullets, and each of those types of .22 caliber bullets were in fact recovered from each and every victim's body, with the mere exception of Mr. Sims, whose body has not been recovered by law enforcement officers, though the defendant admits to using the same gun to murder Mr. Sims, loaded with the same type of bullets in her confessional statement. The brand of ammunition, Judge, will be established as each of the victims whose bodies were recovered as being a Stinger brand, CCI manufactured with a 6 right-hand twist, a .22 caliber, and the same type of caliber and model and make and manufacture as is found in the weapon recovered in Rose Bay. In the instance, Judge, that the pistol was recovered, we know by the defendant's own admissions that is the gun that she used. There will be testimony that will be available to the state to link up the similarities and the class firing characteristics of each of the bullets that killed each of the men that are listed on this chart. Once again, Judge, all of these bullets were hollow points, they were jacketed, and they were all recovered with similar type loaded ammunition found in the weapon when it was found by the law enforcement officers. On each of the vehicles, Judge, when the car was recovered, it was established that one, the car was taken from the victim's body. The body and the victims were all found in different locations by law enforcement officers. In the case of Mr. Sims, a bloody handprint of the defendant, Aileen Wuornos, was found after the car was wrecked by she and Tyra Moore on July the 4th, 1990. It was on the basis of that bloody handprint and the citing by witnesses that law enforcement officers were able to develop a composite photograph, which eventually led to the identification of Tyra Moore and Aileen Wuornos as having a connection with Mr. Sims, the missing individual, and his automobile. Judge, found missing from each of the victims' cars was all of their personal property. All personal property had been removed from the cars. The victims had been ransacked as far as their pockets, and a number of these victims who were clothed had their pockets turned inside out, exactly the same as Mr. Mallory's. In each of the cases, the victim's keys, including that of Mr. Sims, were missing. No keys were recovered with the...
Actually, I don't see one either. Weird. I thought that I posted out Sharon's.
Sims vehicle after the crash by the defendant on July the 4th, as well as any of the keys for any of the other vehicles used by any of the victims, and then subsequently taken by this defendant as part of a robbery plan and thrown away by her and admitted to in her confession. Each of the cars, Judge, also had the prints, white clean-up prints, with cars that the police can establish were located in a condition that they could make a determination that no prints would have been found. So what you have, Judge, is you have a pattern here. You have a signature. You have a fingerprint which establishes the motive and the intent of Aileen Wuornos to rob each of her victims. Now, Judge, in this case, I think it's obvious from the defense that has been offered and argued to the jury is that Ms. Wuornos acted in self-defense. We are offering this Williamsville testimony for a number of reasons, Judge. One is specifically to establish that the defendant did have a premeditated intent to commit both murder and robbery at the time she murdered Richard Mallory. This would also establish of the identification of the ballistics report in regard to Mr. Humphreys, that a spent casing was found some miles away from Mr. Humphreys' body by the law enforcement agents. Next to or adjacent to that spent casing was a bumper sticker that had been on Mr. Humphrey's car. On the back of this crumpled bumper sticker in the gluey area, a latent fingerprint of Mr. Humphreys, the victim of Aileen Wuornos, was found. That casing was taken by law enforcement agents and taken to the Florida Department of Law Enforcement, where Don Champagne, who was previously testified in his courtroom, made a positive identification with the same gun as having fired that casing, the same manufacturer, brand, firing characteristics as was used to kill Richard Mallory by the defendant's own admission. In each of these cases, Judge, Don Champagne will testify that each of the victims were shot with the same type of bullets, .22 caliber, with all the same firing characteristics as that of the murder weapon used to kill Mr. Mallory, as well as a casing relationship to Mr. Humphrey. Judge, in this particular instance, what we can establish is a pattern by this defendant of intentional killings along the highways of the state of Florida. It goes specifically to her self-defense argument. It is relevant to that issue. It is relevant as to the issues of the identity of the murder, of the modus operandi of the defendant. It is also relevant to establishing the use of this particular weapon And it will also be established, Judge, as an anticipated defense, that Tyria Moore was not present during any of these homicides and was fact on some of the homicides not within the state of Florida. So I think, Judge, there are a number of reasons why we'd ask you to consider this. I would suggest to the court that the case law that will be argued by counsel establishes clearly the admissibility of the similar facts that are connected within each and every one of these homicides. We ask the court to consider that on that basis.
Mr. Noah?
Yes, Your Honor.
Judge, we're not quite finished. We want
Oh, I thought you were through. I'm sorry.
I'm sorry, Your Honor.
Oh, my back.
With regard to the proffer, may I respectfully use another exhibit in addition to the one?
Yes, sir. Copy of the available counsel.
I'm sorry. No, we don't have
Judge,
so long.
before Mr. Tanner begins, there's one matter I do need to bring to the court's attention. In addition to the facts, Judge, we anticipate that the medical examiners who examine the bodies of these victims will establish that several of them were shot in the back and with multiple shots, some of which were for the specific reasons as enumerated by the defendant in her confession to eliminate them as a potential witness. This goes to the specific intent of the defendant and the formation of it as she killed Richard Mallory. As an additional item, Judge, that will be proven by the lawyer's dual testimony, the multiple shots to the back to victims when they were helpless, unable to defend themselves, in conditions where they could not have in any way inflicted any type of injury to Aileen Wuornos.
Mr. Tanner?
Thank you, Your Honor. Your Honor, the second demonstrative chart that we would like to have you look at to assist you in determining the similarity and the pattern of criminality in this case is before you now, and it may be marked with an exhibit number after. And we're going in the order, Your Honor, in which the bodies of the victims were found. The first involves Mr. Richard Mallory, which is the substantive case which is on trial before the court, and it's indicated by a red marking disc. And as you can see, the automobile and the body were found, as you have heard in this trial, right in northeast Volusia County. The next chronological homicide that was discovered by law enforcement was the body of one David Spears, a 43-year-old white male. His body was found in a wooded area.
Hey, Jay, welcome in.
County on June 1st, 1990, in this area, just down below the Orange Lake, between the Orange Lake and the Ocala area off the interstate. I'm sorry.
In Marion County?
No, I'm sorry, Your Honor. I was on the automobile. His body was found in Citrus County. The automobile was found in the Marion County location just off of the interstate. The third body found was the body of Charles Cascade, indicated by the green lettered disc. He was a 40-year-old white male. He was found in Pasco County on June the 6th, just 5 days after Mr. Spears was found. And he's further down the interstate between Ocala and Tampa. His automobile was found up closer to the Ocala area, as indicated by Disc 3A in Marion County. The body in Pasco, vehicle in Marion. And then comes Peter Sims, Your Honor. He's the deceased, apparently, that was involved in some type of work connected with the ministry. She calls him a missionary or something like that in her confessions. But he was a 65-year-old white male. He was reported missing on June the 22nd, 1990. His vehicle was found in Marion County on July the 4th, 1990, as here in 4A. Now, her confession tells us that she went somewhere up the interstate, and a relatively short distance across the Florida-Georgia border, she...
Tell me they're not fucking twins. Are you fucking kidding me right now? Taking another pic. Hold on. I'm going to post this one too. Tell me we're lying.
Where the killing took place, she left the body, covered it, and she just could not give us a location. The body still has not been found, but as Your Honor knows, even if we were trying a murder case, and that was the only case, you don't have to have a body to prove corpus delicti. The body of Troy Burris, Your Honor, also a white male, age 50, was found in Marion County on August 4th, 1990, indicated by the orange disc. His truck was found on July the 31st, 1990, also in Marion County. They were in close proximity. The body was found in the woods, and the truck was found abandoned. The body of Dick Humphreys, a white male, age 56, was found in Marion County on September 12th, 1990, as indicated next to the Ocala area just off the interstate, and his vehicle was found in Suwannee County on September the 19th, up here just off the lakes, off of Interstate 10 to the west of Lake City. And finally, the body of Walter Gino Antonio, a white male, age 60, was found in Dixie County on November the 19th, 1991, as indicated by the purple disc number 7 off of State Road 27. His vehicle was found on November the 24th in Brevard County, below Scottsmore. Your Honor, the area in which the killings occurred and in which the vehicles occurred were all north of a line generally drawn east and west from Tampa over to Brevard County, just below Scottsmore, and on the north, just about the Florida border, Florida-Georgia border, perhaps slightly above the border into the Georgia area, but within a few miles, according to her statement. And of course, on the east, by the Atlantic Ocean, and on the west, by a line that would be easterly of Tallahassee. This shows the area, in effect, of operation in which the murders occurred, the robberies occurred, and the thefts of the vehicles. I'd like to briefly, Your Honor, touch upon her reference to these murders in a statement,
Defense attorney's done it.
part of which you heard yesterday, when she gave her confession to Deputy Larry Morzeppa and others. She talked about all of the murders. She specifically earlier, as she went through her confessions, admitted 6. She kept thinking that she'd only killed 6 people. She said she couldn't remember their names, didn't know what all their names were, and sometimes got the murders intermingled, because she talked about one and then say, oh, no, that was another one, and then she would go to that one, and then she would come back. So that's one of the reasons, at least up to this point, we had not attempted to introduce the videotape of the confession, because it was virtually impossible to edit it in such a way that it only dealt with Mallory murder and make any sense whatever to the jury and maintain any credibility, because it would have had to have been edited, spliced, and literally butchered to the extent that it would have been difficult to have a meaningful flow without having the surrounding information. And because of the posture of not presenting Williams rule evidence early in the case, and certainly I think that was the better procedure for the court and for all of us, we were not able to present it. But let me just briefly touch upon what she said about these various killings. You've already heard how she described her killing of Mr. Mallory, but with regard to David Spears, whose body was found in Citrus County on June 1st, 1990, she's talking about killing. And I'm on page 34. She says, the truck, yeah. And when I got back there, he started getting vicious to me. And I jumped out of the truck, and he jumped out of the truck and ran to the car. The door opened, and grabbed my bag, grabbed the gun out, and I shot him quick as possible. I shot him at the tailgate of the truck, and And then he ran around to the driver's side trying to get in the truck towards me, which was weird, towards me. And I just ran into the truck towards him, and I thought, what the hell do you think you're doing, dude? You know, I'm gonna kill you, because you were trying to do whatever you could with me, and I shot him through the door. And then he went back, and I went right up through the driver's side, and I shot him again. And he fell back, and that's all I remember on that one.
Look that up real quick, because I couldn't really remember from watching docs or movies, Jay. Asking how did she get on the police's radar, so I literally just grokked how did she get on the police's radar, and it says Aileen Wuornos got on police radar through a combination of witness tips, physical evidence, and her own associates turning her in, or turning on her rather. Timeline of capture November 30th, 89. Tyree Moore, who we've already seen testify. Wuornos' girlfriend visits police in Daytona Beach, gives vague info about Richard and a female companion. July 4th, 90, Wuornos arrested for outstanding warrant, carrying a concealed weapon in Volusia County. July 25th, Tyler Moore flips, tells police Wuornos committed the murders, implicates herself as a witness. July 26, 90, Wuornos arrested for murder of Peter Sims. DNA evidence from scene. That's not even who this trial is for.
And then she goes on to Charles Cascade, the man whose body was found in Pasco County on June the 6th. And she's talking about Mr. Cascade, and she says,
bunch of fucking
like that
rats.
guy, he's a drug dealer. He had $20, and he wasn't going to give me any more money. The one with a 45 on top of his hood. She goes on to say, and he would be there, and I found the spot and everything else, and he crawled in the back seat, and I crawled in the back seat. They're about to have sex, according to her. And he said, you fucking bitch, and all this stuff, and I said, you fucking bastard. And you were going to blow my brains out.
About that.
I kept shooting
Actually,
the back seat.
too.
And then I got out, and I kept shooting. And then I drove up 52 and dumped his body off, which is very hard for me to get in the car and drive off. And he was still naked. I was always stripped first. And after I shot the guy, he crawled back in the back seat, and that was strange. You see, the seat was over like this, and he got in and laid down. Then he said, you fucking bitch, I'm gonna die, or something like that. I guess you are, you son of a bitch. You were gonna kill me anyway. Then you shot him some more in the back seat. You reloaded, that was the question. You shot him 4 times? And she said, when I saw the gun, I sort of flipped out, and I knew he was gonna kill me. In that particular case, he claims that he had laid a 45 caliber pistol on the hood of the car, and I think she shot him 9 times. She just continued to pour bullets into him. Said she was, in her words, pissed off. Then on Peter Sims, Your Honor, this is the man whose body has not yet been recovered from South Georgia on June the 22nd. That was reported missing from Marion County. She said, let me see the third guy. I had a problem with, let's see, I think the next one's,
Mr. Tanner, what page?
I'm sorry, page 36. I'm talking, he was a Christian guy or something. I didn't know he was a Christian guy. He was nude. This is the one in Georgia, I think. He took a sleeping bag, he took it out in the woods, and when we got nude, I had taken my bag with me that time, because I'd said, well, if we're going to go out in the woods, I'm not going to give him an opportunity to rape me. And you know, this is a woman who solicited sex with each of these men. He goes out there and takes her clothes, but she says she's not going to give him an opportunity to rape her. And that's this time this guy gave me a problem too. So I whipped out my gun and I said, you know, I don't want to shoot you. And he said, he didn't say anything. He just looked at me and said,
He says it like it's above the realm of possibilities for these men to take her out here, to take any woman out in a position like this, and then do whatever the fuck they want. Like, Jesus Christ.
And I said, no, I know you were going to rape me, because he was getting physical with me again, and I knew. And he said, fuck you, bitch, and started to come at me. And he said, you know, trying to get the gun from me. We struggled in that one, and he tried to get the gun from me and stuff, and we're struggling with the gun and everything else. And a couple of bullets shot up in the air, and finally I ripped it away, and I had the gun in my left hand, and I put it back in my right hand, and I shot him immediately. She goes on to say, and I'm positive the only one I left in Georgia is that missionary guy. And you know, question there, She goes on to say, which I didn't know he was a missionary. I had no idea. Says she can't find the body, and she talks about it being way back in the woods off the freeway and describes that. She goes on, she said, I remember the missionary guy. I shot him once, and I thought to myself that, you know, I really don't want to do this to you, guy, but I'm going to have to, because you're going to, if you live, if I let you live, you're going to tell, you know, and who I am and all this other jazz, and I'd probably get caught, you know. Question, so you had to kill him to silence him, basically, is that what it boils down to? Answer by Ms. Wuornos, yeah. But it was bitterness of what you were doing to me. You see what I'm saying? Like, hey, dude, you're going to rape me, you're going to kill me, or whatever you're going to do. It's not going to happen, because now I'm on the other end of the stick, see? Question, you're in control? Yeah. Troy Burris, he was a delivery man, drove a sausage truck in Marion County. His body was found August the 4th. She goes on to talk about him. She says, and then we got this guy in a truck. Question, we got this guy in a truck, sausage truck, and he gives the location. He asks her, did you do that one too? And she says, uh-huh. And then she goes on to say, oh, I remember him. He's the one. He has to ask me what he was going to kill me. Question, which guy was that now? Answer, in the sausage truck. Question, the guy in the sausage truck was going to kill you? Answer, oh, yeah. Question, how many times? How many times you shoot him? Answer, God, let me see. I shot. He physically attacked me, and he laughed. He pulled out a $10 bill. This is all you fucking deserve, you fucking whore, like that. And I said, wait. And then he threw the fucking money down, and he was standing in front of the truck here, and he had the door open here, and he just came. He didn't know that I had a gun or anything. And he came at me, and we were fighting. I mean, we were all the way in the weeds and everything, fighting. And I got away from him, and I ran back to the truck. I had my gun in the back, and I ran in the back real quick. And now we're still fighting, and he realizes I got a gun. Now I finally got a fighting, and somehow I kicked him or something. He backed away or something, or I pushed him or something like that. And he backed away, and I pulled my gun out, and I said, you bastard. And I think I shot him right in the stomach or something. Question, okay, did you shoot him again after that? Yeah, because I shot him, and he turned around, and he was going to start running. So I shot him again in the back, if I remember right. Question, so all these men you killed, you used the same gun each time? Uh-huh, was the answer. She talks more about the killing of Mr. Burris. And she says that, and he started running, and I shot him in the back, and then I ran up to him. You fucking bastard. Boom. I shot him again. I shot him 3 times. Question by Mr. Muncher on page 56. Okay, so when he started to run away, didn't you just think you could just let him go? I mean, he's way out there in the woods. There isn't any telephones for miles. No, he wasn't. He was running towards me, and I shot him. Then he started to go away from me, and I shot him again because I thought, well, you know, the bastard, he's going to rape me and shit. Did you have to chase him to catch him? No, he didn't run very far. She goes on to talk about Dick Humphreys. He worked for the HRS department, Your Honor. His body was found September 12, 1990 in Marion County. She talked about him, and she says, and I pushed him away again. And I pushed him, and he kind of went to the side of the car, and I shot him there, and he walked. I'm sorry, 38F. And he walked up to me, and he started struggling with me. And then I shot him, and then he stepped back and lost his footing on this little grill job. The question is a little incomplete. It says, picked him off the ground. I couldn't understand what that meant. What the answer was, yeah, and then he got back up and he started coming at me again. So I shot him again. And then when he fell, I said, man, you're an asshole. Why the hell did you? I would never hurt you or nothing, man. I had to for the road, and then he was doing, I felt sorry for him because he was gurgling and all that bullshit. I shot him in the head and tried to get him out of his misery.
Real quick, as we go through this very descriptive rundown of, I guess, you know, these are in Eileen's own words, right? This interview that they're reading out here. Pretty interesting, regardless. Kathy coming through the old Venmo with 420 this morning saying, passing the plate for Pastor Steve, and that gets you right on the wheel. And I didn't show this off earlier, but I do got something new for this new wheel that we got rocking and rolling. I've still got the Hell Yeah magnets. I saw some people making some posts. I see Tiff got a shirt. Wildside got some goodies. Everybody should be getting some goodies. I just sent out a lot of stuff last week or the week before. Some shirts. I think everybody's called up or going to be called up here very soon anyways, because now I got Life Artist info also. But we got the Hell Yeah magnets, the Publicly Buzzed coasters, and I've got Publicly Buzzed stickers, and then these are brand new right here. Now it's hard to really tell what I'm explaining because there's not really, it doesn't come through on the camera well, but these are stickers, and these are the Savage, you know, logo that we use here. I need to put this as an emoji if that's possible. Savage sticker, but the thing that's cool about it is it's like a canvas, like it's textured, like it's not smooth, like it's actually, it has like some kind of canvas matter to it. I think those are cool. So those will be part of the new wheel as well for whenever we make it to one. Hell yeah. And again, new folks that did not hear earlier, brand new video on Wrestle Plunge today, 4:45 Eastern. There's a wheel that's attached to that, of course, for a free t-shirt. And we got a brand new t-shirt in the shop, which is really cool. A pit crew shirt for the fine folks here in the Buzz Nation.
San Antonio, retired police officer, Your Honor, body found in Dixie County, November the 19th. The last killing we know about. How many times did you shoot him? Twice, I think. Okay, now, did you feel when you thought he was a cop? Answer, at first, because that one guy, the HRS guy, was telling me he was a cop. And I said to myself, that guy was an HRS guy, so this is another faker. He's just trying to get a free piece of ass, and that's all I thought. He goes on to say, yeah, it pissed me off, because he said I said this guy's a faker. He's trying to get a free piece of ass. Question. Well, when he shot him the first time, what'd he do? Well, we were struggling with the gun and everything else again. He fell to the ground. He started to run away, and I shot him in the back, right in the back. And then I questioned, what did he do then after you shot?
Look at this intense argument that seems to be unfolding right here that we can't really hear what they're saying between an attorney and Aileen Wuornos. She seems like she's getting pretty pissed off here.
Shot him in the back. Answer. He just kind of looked at me for a second, and he said something like, shit. What did he say? I think he said, you cunt, or something like that. Some, you cunt, or something like that. And I said, you bastard, and I shot him again. And then what happened? And then I just got in the car and took off. Did he say anything more after you shot him? No. Did you shoot him in the back again? Did you shoot him someplace else? I think I shot him in the back one more time. Yeah, I shot him near the head or something like that. I just kind of randomly shot. I kind of turned my head and shot. Your Honor, we would like to present legal argument in a moment. May I have this?
Yes, sir.
Your Honor, please report.
Let me instruct us that it appears we're going to be another 30 minutes until the jury come back in 30 minutes.
Morning, Simi. Happy holiday Sunday. Yeah, Aileen is very, very angry about all of the about what's being read out to the court, which again, this is outside of the presence of the jury, I'm pretty sure. Yeah, so this is right now counsel and the judge discussing evidence and testimony outside the presence of the jury, I guess, to see if this can be brought in. And man, she is not happy talking to her lawyer. Man, it ain't good. This here right here? This is a bit crazy right here, isn't it? Like, what is actually going on? It looks like there's something in the... It looks like there's like a... It's like somebody put a waffle iron on her hair and like fucked it up just in that one place, right? And she's like, oh, I've got to go to work now. I don't have time to fix it. Loud noises. Oh, whoa, there we go. Shot at the entire fucking courtroom. Packed house in here, all the way to the back. Oh, who's this? Man, get a shot of some 1992 folks who are here, who, you know, may be related to victims, who may be just spectators, who may be related. Well, I wouldn't say that Wuornos would have had anybody related the way her family treated her. Some people that knew her. Oh, the jury's coming in. They're just like, here they are! Guess it really don't matter this long after, but... It's good. 35 years there? Let's go to the jury room. Honestly, that's a good question. I'm not really sure. I know that she had a terrible family. She ended up in the streets, so I don't know after the fact. She ended up living in the... Oh yeah, she was abused young too, I think, by like a father figure maybe, or something like those regards, or an uncle, something real bad like that. I'd have to look back. And then ended up... Yeah, she ended up getting pregnant super young. I think this is coming back to me. Yeah, she got pregnant super young, ended up either having to give the baby away or losing the baby, and ended up living in a very harsh winter in Ohio in the woods. And that's when she decided to come to Florida to prostitute, but also for the warm weather, just because it wouldn't be as cold.
Please the court, just a few further comments regarding the physical evidence in this case. Judge, during the course of the defendant's confession, she described numerous articles that she removed and robbed from each of her victims. As the evidence was established in this case, in conjunction with the weapon that was found in Rose Bay, also found in Rose Bay by the law enforcement officers, were a billy club, handcuffs, and a flashlight and handcuff, not the billy club. Each of those are described by Ms. Wuornos as being the property of her other victims. In addition, Judge, found at the storage location where Ms. Wuornos was established with renting the mini warehouse, the Jackson Mini Warehouse, was found a briefcase, the property of Mr. Humphreys. Inside that briefcase were found articles of her fingerprints, which were identified as belonging to Mr. Humphreys. In addition, that specific briefcase was identifiable as being that of the victims. Other personal property of Mr. Humphreys was also located inside the storage area that was rented by the defendant. In regard to the killing of Mr. Karskadal, a .45 caliber gun which the defendant described as being on the hood of the car was pawned by the defendant using an alias name of Cammie Marsh Green in June of 1990. That pawn slip was recovered, a fingerprint was obtained from it and identified as being that of the defendant in this case. Also, Judge, it was established that an Indian blanket which was found in Jackson Mini Warehouse was the property of Mr. Karskadal. That was another article he was traveling with when he was coming from Missouri down to the state of Florida, and the defendant robbed him of his property. Continuing on, Judge, in the case of Mr. Sims, whose car was found after being wrecked by the defendant in Tyler Moore on July the 4th, was the defendant's bloody print. Inside that car was a Windex bottle. That Windex bottle, Judge, I would submit to you, was used by this defendant in various cases.
After I'd grokked or, searched to see a little bit more information earlier about how the police kind of latched on to Aileen. Also here it says dumb mistakes. used real IDs at pawn shops under aliases that she repeated, drove victims' cars openly with Moore, which I think we heard a little bit with her earlier, well, last week, or maybe the week before, kept victims' belongings, watches, rings, and cameras, and then confessed to Moore ultimately of killing everyone, and it's what ultimately did her in was Tyree Moore flipping for the state. Still looking on here. Tyree Moore betrayal, relationship, lesbian lover since '86. Moore knew about the killings. Moore's deal immunity for testifying against Wuornos, which again we just saw. An impact. Moore testified Wuornos came home covered in blood multiple times, confessed to murders to her.
Make sure she had access readily to wiping down the car so there would be no prints, so as to prevent law enforcement officers from finding her prints on a vehicle. Only the wrecking of that car and the fact that people came upon them rapidly to proceed to assist them caused her to be unable, and in fact she was bleeding from the wreck, to wipe down that car to eliminate any of her prints as she was able to do on the other vehicle. During the course of her confession, Judge, the defendant was shown photographs which had been introduced to evidence before this court of Mr. Maurer. In addition to that, she was shown photographs which established in her story a facsimile of a badge that would have been carried by Mr. Humphreys,
what's up, dude?
who was a former retired chief of police in the state of Alabama, which she identified as being an article which she had thrown away after shooting Mr. Humphreys. In the case of Mr. Karskadon, she identified his car as being the car that she had removed after shooting Mr. Karskadon multiple times. In the case of Mr. Antonio, she identified his motor vehicle as being the car she robbed him of. In the case of Mr. Spears, she identified both his face and the truck in which she claimed to have shot and murdered Mr. Spears and then taken his truck and robbed him of it. Subsequently, Judge, in the course of the interview, she discusses a clipboard. She describes that clipboard as belonging to Mr. Burris, the sausage truck driver, and the money that she took from Mr. Burris during the course of her robbing him of her property. In the cases, Judge, of each of the individuals that are related to her confession, which had been already ruled to be admissible by Judge Graziano, she described the various properties which the police have either located or been unable to locate as coming from her various victims, her war trophies after having murdered each of these men. In the case of each of these men, Judge, the autopsy revealed and the physical evidence revealed that these men were helpless victims. They were helpless to the extent that, Judge, in the case of Mr. Humphreys, the autopsy revealed the physical evidence that is available to the state is that Mr. Humphreys was shot no less than 4 times. Excuse me, Your Honor, I'm sorry. I'm looking at Mr. Burris, excuse me, Judge. In the case of Mr. Burris, the shooting was described by the defendant who was shot. According to the autopsy report, he was shot once in the chest and once in the back. Once again, Judge, all the bullets recovered from the victim's body will correspond as .22 caliber manufactured CCI Stinger, hollow point copper coated with 6 right-hand twists, which match the grooves to the weapon that is recovered. In the case of Mr. Humphreys, Your Honor, Mr. Humphreys was shot once in the head, twice in the back, has multiple gunshots to his wrist and hand in a defensive posture, and has a total of 6 bullets or fragments removed from his body, of which 2 are to his back and 1 to his head, which is described in detail by this defendant as being a shot to put him out of his misery after she had shot him and incapacitated him after she had been with him in his car. In the case of Mr. Antonio, Your Honor, the autopsy photo revealed he was shot at least 4 times, once again with the same weapons, .22 caliber hollow points. Those shots, Your Honor, reflect that he was shot at least once in the head, to the back of his head, twice to his back, 3 times to his back. 3 shots to the back, Judge, and 1 shot to the head, the coup de grace. In the case of Mr. Karskadon, Your Honor, once again, he was shot with .22 caliber. Those bullets were recovered from his body. They match in every aspect the manufacturer, the type of firing characteristics is found with the gun that was found in Rose Bay. And there are a total, Your Honor, of 8 bullets recovered from his lower chest, his upper abdomen, and his upper arm. submit to you, Judge, jumping back to Mr. Humphrey, the cartridge case, which was found adjacent to a bumper sticker, which was peeled by this defendant in her efforts to conceal his car after she stole it, was found adjacent to that cartridge case. The firing pin of the gun, which is now in evidence, was matched by the experts and established that that casing was fired by that gun. Once again, Judge, in each of these cases, the victim's personal property was taken, their bodies were left to rot in the woods, they were all found in various stages of decomposition, with the exception of Mr. Sims, whose body has been unable to be located. Their cars were stolen, and they were shot multiple times, many of which were shot in the back and or the head of the back, which exhibit a fact and a pattern that this defendant was not acting in self-defense on any of these occasions. In addition, Your Honor, there was other similar fact evidence offered by the state in the form of the testimony of a Mr. Robert Kopis. Mr. Kopis, Your Honor, was an individual traveling on the interstate when he was confronted by Ms. Wuornos. Mr. Kopis says that on November the 4th, 1990, Ms. Wuornos approached him at a truck stop. She advised him that she had had a car problem, that her Corvette had broken down, and that she needed to get back to the Daytona Beach area where her 2 sick children were waiting for her, and that if he could give her a ride to Orlando, which was closer, her sister would come to pick her up. On the way, Your Honor, Mr. Kopis, seen within Ms. Wuornos' bag, noticed a pistol. He became scared. As she began to talk to him, she propositioned him for sex. He advised her that he was not interested in that. He'd been a happily married man for 38 years. He appreciated the offer. It was nice for his ego, but he did not want any part of it. When he rebuffed her, she became agitated. She started talking strange things to him. She started to scare him. With that, he wheeled him to a truck stop where he was able to get the defendant out of his car on the pretext by giving her money for her to go call her sister. As she stepped out of the car, he immediately locked the door behind himself. At that point, she screamed out to him as she fumbled with her purse trying to get something out of her gun that was within. "You dirty old bastard, you're not the first one I've killed, you won't be the last." We submit, Your Honor, that that is William's rule testimony. It goes to our modus operandi of waylaying these travelers with bogus stories of a woman in distress and then claiming that they were there to sexually molest her. We submit, Judge, that in addition to that, we have the testimony of a Mr. James Dalla Rosa. Mr. Dalla Rosa once again picked this woman up hitchhiking. She approached him. She propositioned him. He turned her down. When he turned her down, she became agitated. As she left his car, she slammed his car door and began cursing at him. He was able to get away with his life. I would submit to Your Honor that once again shows the modus operandi, the propositioning nature of this defendant, and upon being rebuffed, the fact that she becomes violent. We would submit that all of these matters, Judge, are Williams rule testimony clearly. They go specifically to the heart of this issue. And I would also add, Judge, that defense counsel in their questioning of witnesses has opened the door in talking about composite photos and talking about Mr. Sims's car, and eliciting testimony themselves, which has opened the door for the introduction of this testimony.
It's just argument. Go ahead.
So we would ask the court on those bases, Judge, to allow the introduction of the similar fact evidence as to each and every one of these crimes which the defendant has confessed to, and the murder of at least 6 other individuals in addition to Mr. Mallard. Judge, I also have photographs. Yes, sir. If the court wishes, I also have photographs of some of the items that will help to flush out the argument. Photographs of some of the articles and items that were removed and identified as being those of the victims, as well as the autopsy reports that the court can review, and the victim's photographs.
Mr. Dulles?
Yes, Your Honor. You just heard, just over a half hour's worth of presentation from the state as to what they believe their Williams rule evidence will show. Under Freeman v. State, it's cited in 545 Southern 2nd 915, Chapman v. State 417 Southern 2nd 1028, and numerous other cases which we could discuss with Your Honor at a later point if it becomes necessary.
Sorry, I missed the first citation. 545,
545 915,
915.
915, 417-1028, and there are a number of other cases along those lines.
Judge, we object to a number of other cases. The council has a case.
Your Honor, this is argument. You said I should not interrupt Mr. Demore. I don't appreciate being
Go ahead.
interrupted.
Oh, the hell.
We don't have to holler now. Back in here pretty well.
You rarely accept them.
A second week ago, and I still have my hearing.
Yes, Judge. We would also refer, Your Honor, to the Earhart treatise that Mr. Daly argued to the court on a previous occasion. In essence, once the state indicates to the court that it intends to introduce collateral crimes evidence, the initial question before the court, before we get to issues of admissibility, relevancy, all of those types of things, the initial question before the court is whether there is a quantum of proof that the state has to support that evidence. Cases usually, since most trial courts, the decision that they make with regard to that evidence oftentimes has a pre-trial hearing on it. Most judges are not in the posture that Your Honor is in.
Dude, she's been mad this whole morning.
However, the state bears the burden of establishing by some quantum of proof that...
Yeah, I know the jury just came in, but you saw them go on past, but this is still outside the presence of the jury, and it's the judge and counsel discussing evidence and testimony, and I guess that's what the state is. I'm not sure. It seems to be that the defense is pretty mad. I don't know if they're mad because they didn't already know that this was going to be introduced, or how it's going, or if the judge is going to make some kind of ruling that all of this will be allowed, because it's pretty damning everything that they've basically went over through Eileen's own words here.
The collateral crimes evidence they wish to introduce is real. It really is out there. The quantum of proof under the case law is clear and convincing evidence. We would submit that before Your Honor entertains the Williams rule issue...
You said I could do it this way!
...hearing at which Mr. Demore will be required to prove everything he's told you in the last half hour. To prove by clear and convincing evidence that it's accurate. To prove by clear and convincing evidence that it exists. Only then should Your Honor consider the issue of whether the evidence is admissible. But until there is a quantum of proof on it, Your Honor cannot take the chance of introducing it and allowing the jury to hear it. The proof has to go both to connecting the accused to the collateral crimes evidence, to the validity of the facts which the state has proffered as to the collateral crimes evidence, and to the relevancy of the evidence. So initially we would request a hearing. And Your Honor, as I indicated, you heard quite a great deal from the state as to what they wish to prove. Initially we need a hearing in which some proof is presented to show Your Honor that this evidence exists. Absent that, all you have is an oral argument, not even a proffer, and you do not have a sufficient quantum of evidence before you on which to rule. Putting aside the issue of proof, I don't know if Your Honor wants me to deal with the evidence itself, but there is quite a great deal that needs to be said with regard to the evidence. Initially, if you look at the chart, well, let me get to that in a moment. When a court has a Williams rule issue to determine, because of the fundamental importance of the right to a fair trial that the accused has and that Your Honor is aware of, when that type of issue is before the court, the initial question before the court is, what is the evidence being admitted to prove? The second issue deals with prejudice and the necessity of the evidence to the state's case. And what I would like to do, if it's okay with the court, is to go backwards, to start with the necessity prejudice issue, and to then turn to what the state apparently wishes to prove with this evidence. Historically, the two areas which courts have most often entered reversals on when Williams rule type evidence is admitted deal with evidence which the state asserts to be necessary and not prejudicial, which appellate courts find to be prejudicial and unnecessary, when the evidence confuses the jury, confuses the trier of fact, or becomes a feature of the trial. In this case, the best example Your Honor is ever going to have of confusion between whether the evidence is being admitted to prove propensity and whether the evidence is being admitted on a relevant material issue is what you just heard Mr. DeMoore say. What you heard the state argue in Mr. DeMoore's presentation was, at its heart, a propensity argument. At its heart, it was not an argument dealing with preparation, with intent, with common scheme, with lack of mistake, with opportunity, with identity, with any of the classically recognized Williams rules exception areas. The argument, although some language was used, the argument basically was a propensity argument. And that's the way the jury is going to hear it. That's what's going to happen when the jurors in this case hear that evidence. We do not try people in this country on propensity. We do not try people on their character. And we do not try people on anything other than the crime alleged in the indictment. What you will see the state do, should this evidence be admitted, is in essence to present a propensity prosecution. There's no other way to do it, I would submit, given the evidence at issue. Secondly, the collateral crimes evidence will become a feature of this trial. Another of the classically recognized area where courts have found that admission of Williams rule evidence was both unnecessary and prejudicial. There is no way that a reasonable group of jurors can view this evidence and not consider this evidence to be what the case is all about. And there is no way, as defense counsel, that we can allow, well, there's two issues. One is, in presenting this evidence, the bulk of this case will become a Williams rule case. Secondly, there is no way in good conscience that we, as defense counsel, can allow this evidence to be presented and then not cross-examine on it. So by definition, what will happen in this case is, rather than the jury ascertaining whether beyond a reasonable doubt the state has proven that Ms. Wuornos is responsible for the homicide of Mr. Mallory, the collateral crimes evidence will become the feature of this trial. The collateral crimes evidence will be what this jury will be focused on. The collateral crimes evidence will be what is going to sway them one way or the other on the issue of guilt. And in essence, the jury's view is going to be either Ms. Wuornos is innocent of all of these cases or she's guilty of all of these cases. Mr. Mallory's case will be lost in the shuffle. It is a classic example of a situation in which collateral crimes evidence should not be admitted because it will become a feature. You may have a different situation before you if the state were to select one or two of the other instances and focus on those, but you don't have that here. You have the state seeking this wide range.
I really can't keep up with this guy, though.
To be admitted, that is unnecessary for the jury's consideration. Going back to the initial issue, to the relevancy of the evidence, you heard quite a great deal from Mr. DeMoore and Mr. Tanner, but you really did not hear, other than certain bold statements, you did not hear argument on why the evidence is relevant to any of the recognized Williams rule criteria. What you heard was a great deal about the other offenses. You heard a great deal about Mr. DeMoore's version of when they happened, where they happened, how they happened, all sorts of things along that nature, but you did not hear how they fit to preparation, how they fit to opportunity, how they fit to lack of mistake or accident. What they have to do with any of the classically recognized Williams rule criteria has not really been argued to you. You have a statement, we want this to prove X, and then you have a propensity argument following up the statement. In this case, when you look at the evidence itself, it is not something, when you taking it in its totality, taking everything that the state wishes to present here, it does not fit into any of those Williams rule criteria in a manner that will not confuse the jury. It doesn't even fit when you look at the facts of the cases themselves. And Your Honor, I'd ask you to take a look at this chart, for example, to start with, that the state has prepared. There are 22 categories on this chart. Supposedly 22 similarities between the cases. If Your Honor were to go down to the first category listing 22 caliber revolver used, and then you count down with me, the next 1, 2, 3, 4, 5, 6 categories, that's all the same thing. All of that relates to a 22 caliber weapon. What you have here is a chart, and just use the chart to look at whether these offenses really are similar or not. You have basically a matter relating to a .22 caliber weapon which has been broken down into 7 categories as if there are only 7 similarities. That's not the way the case law requests that the court analyze it. If that were the way the case law would request it, that you could have categories here indicating all the victims had shoes. They all wore socks at some point. They were all Floridians. So you can go on forever if you're going to make a similarities chart, but the focus is what is similar on the Williams rule issues. What is similar on intent? What is similar on opportunity? What is similar on preparation, on identity? Under those criteria is where you look at the similarities. And under those criteria, what you have here is drastic differences. First, you have a case in which there is no body. So in terms of substantive proof, we know nothing about that decedent. His body has never been recovered. Secondly, you have distinct dissimilarities between cases.
I likes to hear himself talk. This is our new Rosen.
Mr. Moore's presentation to you. You have certain individuals who, taking the state at face value at what they asserted to you.
This judge was like, yeah.
Were clothed.
This was the defense he'd be like, not having it.
Mr. Mallory was not shot either in the head or in the back. Certain other individuals were shot either in the head or in the back. Items of property were missing from some individuals. Items of property were not. Other items of property dealing with other individuals, there's no connection of Ms. Wuornos to them. You have a distinct difference in ages. You have a distinct difference in area, and that's the other thing that's something for Your Honor to consider. The state provided you with a chart saying another similarity is that you have this happening in this area. The area is North Florida. And again, if we're going to take that level of analysis to tie up similarities, we could say it happened in the Western Hemisphere. To draw similarity. It's not a limited type of area. It is a broad statewide area. Some of the decedents were found in wooded areas. Some were not. Some, contrary to the chart, were traveling highways. Some were not. These are not cases that are all interlinked. These are not cases that concern a common crime spree situation, such as the Remetta case, which the state cited to Your Honor the last time we argued this issue. You heard Mr. DeMoore indicate that one of the purposes of the Williams rule evidence has to do with the anticipated defense in this case. And we would submit to Your Honor that until the defense is heard, until the defense decides what's going to be done defense-wise, it is improper for the state to get into anticipating what the defense is going to do and affirmatively trying to rebut before the other party has gone forward. And finally, Your Honor, what you have in this type of situation is a situation where a reasonable juror, listening to this evidence affirmatively, before the defense has had a chance to go forward, cannot but see it as a feature of the trial. What you have at the same time in this case is a case where defense counsel have to address that evidence, are going to have to deal with it. Not only will that make it a feature, that will put Ms. Wuornos in the position of having to, in this case, testify as to things that would affect crimes that are not on trial here, that are not before the court. And it puts the defense in the ultimate untenable position to have to address affirmative proof on something that is not an issue before the court, that is not alleged in the indictment. With those comments as to the general evidence, with charges pending in other counties. With those comments as to the general evidence, let me talk a little bit about Mr. De La Rosa and Mr. Copus. These two incidents, and again, taking the written addendum at face value, these two incidents have clearly nothing to do with the incidents related on the chart. If we are going to start bringing in every time an individual on trial lost their temper and say that's Williams rule, every time an individual on trial did something that other individuals don't approve of and say that's Williams rule, if we're going to start dredging up everything an individual did, irrespective of how closely connected to the case it is, then we have truly
court reporter. I just sent you some stuff out. Good morning.
Ourselves in a position where we are not following the precepts of the Florida Supreme Court in trying cases based on what is alleged in the indictment. Then what we're doing is we're trying cases on someone's character. And the problem with that is, if that is the case, that's the way we are going to try it, then at least there should be notice, statutory or in the case law, relating to us as defense counsel that we need to prepare a
This guy's still
defense
fucking talking.
on that
Jesus
issue.
Christ.
At least there should be an allegation in
Dude.
the indictment so that we can
This is
prepare
rough.
on that issue. Because as defense
This
counsel
morning.
in good faith, we're on notice that you don't defend cases on character, and it's not something that counsel generally prepare. For each of those reasons, we submit that admission of this evidence at this juncture would violate both Florida standards and federal constitutional standards.
It looks like it's one of
Eileen, should Your Honor
Eileen's,
entertain admitting, we would request
attorneys
that
up
an
here
evidentiary hearing be conducted in which the state can establish some kind of quantum of proof by clear and convincing evidence connecting the Williams rule.
What has been spoken here this morning, that the testimony to be proffered is not too remote, that it would be relevant to the allegations contained in the indictment, that it would be established to show an establishment plan, scheme, or design to identify the defendant and demonstrate a plan or a pattern followed by the defendant committing the crime that is alleged in the indictment, and would not solely be used to prove that character propensity. Accordingly, the similar fact testimony will be accepted by the court. When is your first witness available to us?
Judge, we have a number of exhibits that we'd like to get marked. We can proceed almost
Let's see if I got
immediately,
any
Judge, but we'd like
room
to
for any
confirm
more.
by
I
the
want
motion.
you to get the items marked before we
You only get so many.
We don't hold them up anymore than we have.
More members you get.
There's been more recesses for the jury than we have.
More members you get. Let me see. I might have some.
Get those things done. How long do you think?
Judge, I think I can get enough marked in 15 minutes. I can get us rolling in an orderly fashion.
See, I got to replace
Counsel,
some
you
more.
viewed these items?
No, Judge.
The goal for the record has been available to counsel in discovery. They've simply not come to view them. I have noted at least on 4 occasions the request that they come to view, and they have not.
Your Honor, that's, you have these comments made and the parties disagree, and let's,
Yeah, I've been through that before. Everybody disagrees with everything, so we're just going to do it in front of the jury from now on out. Get these items marked. You need to proceed.
Your Honor, let me, before you go.
Yes, sir.
Our request is that a proffer be made as to the,
I'll hear the witness come forward.
but outside of the presence of the jury, Your
I'll
Honor.
hear the witness come forward. I'll hear all the objections you made at every step.
All I'm saying, Your Honor, is if you hear the actual Williams rule testimony in the presence of the jury, once they hear that, there's no way for them to get it on their head. So the proffer should be done outside of the presence of the jury, then Your Honor rules, then the jury hears it.
Proper
If appropriate. Your Honor has denied the motion for the
Yes.
record. Thank you.
Let me,
Respectfully object.
let me have 15 minutes and then we'll proceed with the testimony.
Okay, we're going to move on here. We're going into Investigator Lawrence Horzepa, who we've already seen, is recalled to the stand. Deputy Tony Cameron and Deputy Alan Seabrooks testify as well. And this is a very quick video. This is 19 minutes. So let me go ahead and get Investigator Lawrence's name here, so we can pop it up on the screen. Again, thanks everyone for popping in this morning. I really appreciate it. We're rocking and rolling on a Sunday morning. Hope everyone had, again, a good Thanksgiving. One more time, a quick announcement. First of all, everybody that has been gifted memberships this morning, you have the opportunity Tuesday night to join us, maybe for the first time ever. There's a lot of membership videos that you could check out also here in the Buzz Nation, but welcome in. Also today at 4:45 Eastern Time, Wrestle Plunge, my second channel, drops a new video. I drop a new video every 2 to 3 weeks, and the good thing here with the Buzz Nation, here in my True Crime family, in the Murder Church, is that you can get on a special will that allows you to get the possibility of winning a free t-shirt from publiclybuzz.com, and I have a lot of really cool merch. Just to toot my own horn, just straight up, there's a lot of really dope merch on there. And you can get one of those for absolutely nothing, and all you have to do is go to that new video that drops today at 4:45 Eastern and leave a comment, leave a like, and please watch the video to completion, because that really helps out. Watch time is the most important. And leave some hype on that video, and you will get, and I will see your name as a comment, and I will put that on a list. We will spin a wheel for a possibility of a free t-shirt at a later date, and it's usually pretty quick. I will do it within the next week or so. Other than that, tonight at 6, I also go live on that channel every Sunday night at 6 Eastern with some classic wrestling. We're currently in 1990 hanging out. Everyone, welcome the hell in here. Thank you very much. Let's go.
Ladies and gentlemen of the jury, the evidence that you're about to receive concerning evidence of other crimes allegedly committed by the defendant will be considered by you for the limited purpose of proving motive, opportunity, intent, preparation, plan, knowledge, identity, the absence of mistake or accident on the part of the defendant, and you shall consider it only as it relates to these issues. However, the defendant is not on trial for a crime that is not included in the indictment that has been read to you. You may proceed.
Judge, we would request that the state specify which one of those the evidence is being introduced for, whether it's motive and intent, whichever one it is, so that the jury doesn't think it's being offered on all of these things.
Mr. Tanner,
Thank you, Your Honor. Sir, would you state your name, please?
would you like, he wants you to make an offer if you come forward and take your pick.
Yes, Your Honor. If it please the court.
Here are the items that he referred.
Thank you, Judge. Your Honor, we intend to introduce the similar fact evidence of the other murders in this case to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, absence of accident, and lack of self-defense.
Objection to the last one, Your Honor.
Objection is sustained.
Motion for mistrial, Your Honor.
Motion for mistrial is denied.
Motion for curative instruction, Your Honor.
The jury will instruct you all.
All right, it's hard to say. He's all right. Check him out in there. Right now in the chat, I got the Chet emoji. Again, the judge looks exactly like fucking the monster Chet from Weird Science with that haircut. But yeah, we got a Chet monster emoji. We got a bunch of Aileen Wuornos trial emojis now.
Pay no attention to the last comment of counsel for the state as to the last option of the instruction.
May I proceed, Your Honor?
You may.
Sir, would you state your name again, just for the record?
Lawrence Horzapa.
And you were previously sworn investigator Horzapa yesterday, were you not?
That's correct.
Sir, I would like you to
It's just like saying it all the time, knowing it's going to get to that.
look at charts triple I and triple J for identification and ask if you recognize what those charts represent.
Yes, sir.
Sir, with regard to exhibit triple I,
That one is hard to see.
could you tell the jury what it showed?
This shows the central area and northern area of Florida. On this particular map here, we have a small circle number 1 and a small circle number 1A right at the Daytona Beach area, 995, approximately at the Ormond Beach area. Circle number 1 indicates the area where the body of Richard Mallory was found, and circle number 1A indicates the area where Richard Mallory's vehicle was located.
Your Honor, please, we would offer this chart into evidence at this time.
We had a good Thanksgiving.
That's triple I, Mr. Tanner?
Yes, this is triple I.
Objection to triple I is cumulative, Your Honor, to yesterday's evidence.
Objection overruled. Let the item be received and marked by a proper number.
State's Exhibit 42.
There's no further questions to the witness at this time, Your Honor, subject to recall on other issues.
Subject to recall, Your Honor.
You care to cross-examine?
No, Your Honor, but we would like the witness available to us as
You
well.
may stand down. Call your next witness.
All right, that was not very long at all. So we're going to go into Deputy Tony Cameron, and I don't think he's going to be very long either.
Deputy, I may announce your name as Deputy Brooks. It's Deputy Cameron, if not.
Deputy Cameron.
Excuse me. Would you please tell for the record your full name?
Tony Gene Cameron.
And where are you employed, sir?
Suwannee County Sheriff's Department.
How long have you the motion? May we approach?
Yes, sir.
We would
Good like a
make a
Mr.
Richardson motion at this time, Your Honor.
Objection overruled. Go ahead.
Your Honor, we would also move to strike it.
And also a
Strike, I
mistrial.
don't know what it is. Strike all person names, but,
To exclude the witness, Your Honor.
all right.
And also a mistrial.
Sir, were you so employed on or about September 25th, 1990?
Welcome in.
Yes, I was.
Yes, sir. And in what capacity were you employed?
Deputy Sheriff,
And how long have you been employed with your particular agency?
approximately 9 years.
Yes, sir. And some of your duties, is it road patrol?
Yes, it is.
Yes, sir. Now, during the course of your routine patrol, did you come upon a vehicle that was later linked to the homicide of a Mr. Humphreys?
Yes, I did.
And you recall what date that was?
September the 25th, 1990.
During the course of your investigation, did you learn whether or not that vehicle had been in the location where you first saw it for any period of time?
I determined that it had been there for several days.
Was that based upon your investigation?
Yes.
All right. So let me show you what has been marked for exhibit purposes as states triple D for identification. Ask you if you're able to recognize the vehicle portrayed in that photograph.
Yes.
All right, sir. Is that the light blue Frienza that you saw on September the 25th, 1990?
It looks like it is. If I have the VIN number and everything, if you need it verified.
Do you have that with you?
Yes, I do.
Could you tell the jury the
Pulls
VIN
it
that
out
you
of the
had when you
wallet.
ran off?
Get out of this shit, buddy. Out of this.
The VIN number is 1G3JC69P2FK315829.
For the record, Your Honor, the witness is reading from a sheet of paper, no objection to that.
If you'd like to come examine it, sir, you may.
On cross-examination, no.
All right.
Sir, if I may put you on.
Yes, sir.
So let me show you what has been marked for exhibit purposes as states triple J for identification. And ask you if you can tell me, point to the approximate location where you located Mr. Humphrey's vehicle in
Remember.
Suwannee County.
Approximately
Let's see
at this number 6A, near just east of Falmouth,
Okay. And what county would that be, sir?
Suwannee County.
So Swanee.
And that is represented on states triple J for identification as 6A.
Yes.
Thank you very much. Sir, when you found the car, can you tell us what procedures you followed at that time?
When I found the car, there was no license plate on it or anything. And I checked inside the car to see if I saw any identification just laying in the car, and I didn't see anything. So I took the VIN number from the vehicle and ran it with my dispatcher, and it came back to a C.R. Humphreys, and it had a Miami address on the registration.
During the course of your attempt, did you attempt to locate the owner at that time?
At that time, I attempted to locate the owner in Miami, which I didn't have any luck at all. And at a later date, I don't remember exactly what day it was, I was in our dispatch room and there was a teletype posted, and I was just reading over the teletypes, and it had the name
Hey,
Humphreys
Tiff, in the Discord, I saw that picture, man. That was awesome. That looks good as hell. Thank you so much.
on it, the teletype.
Did you recognize from that teletype the name that was on it as being the owner?
The name on the teletype, I said Charles, but
You had C.
I had C. So I contacted Marion County Sheriff's Office.
Now, was it some period of time before you saw that teletype and recognized the significance of your find of the car to the
Yes, there
teletype?
was.
Okay, and what happened once you teletyped Marion County?
They sent two investigators up to Live Oak.
Okay, so did they recover the car at that time?
I had already had the car towed in
Okay, sir.
with the day that I found it on the 25th to an impound yard owned by Bill Nix of Nix Golf.
Okay. At that time, you had no reason to believe it was involved in anything other than possibly an abandoned or stolen vehicle.
Correct.
Okay, sir. And do you know approximately when you notified the Marion County authorities?
Not exactly.
Well, are we talking days, weeks, or a couple months?
Within approximately 2 weeks.
Okay, approximately 2 weeks after you made the recovery. And did they show up pretty much fairly immediately?
Yes,
Immediately.
immediately.
Objection, Your Honor.
Objection, overruled.
Nothing further at this time. Thank you, sir.
Yeah, this guy didn't want to be here. He's like, man. The only thing I can figure is
Sir, let me show you what is now in evidence, the state's 42 in evidence. And ask if you could point, for the purposes of this chart, where it is that you found Mr. Humphrey's vehicle.
Just east of Falmouth at the intersection of 90,
Sir, I'd ask you
US 90.
to place a dot, now for the record, you have in your hand a dot 6A. Is that correct, sir?
Yes.
All right, sir.
US 90 and I-10 intersection
In Suwannee
in
County.
Suwannee County.
All right, sir. Thank you very much. At this time, Your Honor, the state would offer state's triple D for identification as evidence.
Objection, Your Honor.
Photograph the car.
Yes, Judge.
mistrial.
Overruled. That has to be changed.
Would like a mistrial.
Thank you, Your Honor.
Judge, just so that the court is aware, we don't have to ask for breaks or anything, a number of the objections we'll be making will relate to the issue that has already been discussed with the court.
It'll be an ongoing objection.
Actually, yeah, if we could have a running objection, Judge, that'll save a great amount of time.
It's fine.
Thank you, Judge.
State's Exhibit
I hate
42.
this guy.
If I may, Your Honor?
You may.
Joe?
Yes.
We realize our client is fine.
Cameron, who were the two investigators who showed up from Marion County?
I don't know their names.
Were they in uniform or not in uniform?
They were not in uniform. They're here today.
They're here today?
Yes, I've seen them today.
I seen them.
You don't know their names at all, first name, last name, nothing
No.
like that? But they're here outside in the hallway today?
Yes.
Which sheriff's office are you employed with?
Suwannee County Sheriff's Office.
Suwannee County? When withdrawn? When you originally found a Miami address with regard to the vehicle, what did you do in terms of contacting Miami?
I just called down and asked for a deputy to go to that address, and I never heard anything back from them. And I called information to try to find out if there was a phone listed to Mr. Humphreys, Mr. C.R. Humphreys at that address, and there wasn't.
And when you say you called them, who did you call? Who did you call in Miami?
Who did I call?
He's basically literally objecting to the entire case from the state.
The sheriff's office.
The sheriff. Okay, thank you. Nothing further. Your Honor,
Is it true you're not a real cop? It's not true. Okay. Thought I would hit you with that. Just in case.
This witness be released?
Yes, sir. Any objection?
no, Your Honor, subject to recall if the witness
mistrial.
can leave a phone number,
All right,
that's...
sir. If you'll give defense counsel a call where you may be contacted, you may depart. You are a rule that if you're not discussed, testimony that is concluded.
I can be reached at area code.
Just jot it down for us.
Call your next witness.
Deputy Allen Brooks.
Get this other name in here. This won't last long either. Deputy Alan Seabrooks about to come up.
Your Honor, we would make a Richardson motion at this time and request a Richardson hearing.
Your Honor,
Ongoing objection is denied.
if it please the court, at some time, the state would like an opportunity to rebut or at least answer this for protocol record, Your Honor.
Right. When the jury goes to lunch, you'll have an opportunity to say anything.
Thank you, Your Honor.
And to save time for
Sorry for the delay, Your Honor. Sir, would you please tell the jury your full name, your place of employment also?
My name is Alan C. Brooks. I work for the Marion County Sheriff's Department. I've worked for them for approximately 2 years.
So were you on patrol on September the 12th of 1990?
Yes, I was.
And you described at that time if anything happened in regard to your becoming involved in the investigation of the death of a Charles Richard Humphreys.
Well, I was called to a suspicious person's call. I was advised that some children had found a white male laying in
God, imagine that.
cul-de-sac.
Like, you're just out playing. You're a child. Wow. Oh my God! It's a body!
Sack off of 132nd Street near 49th Terrace in Marion Oaks. When I got to the scene, rescue also followed me. We got to the scene and we found a white male laying in the cul-de-sac, apparently dead. The two paramedics that were on the scene confirmed it, and I immediately called my supervisor, and he advised the evidence techs and the investigators.
Now, when you arrived, can you describe what happened once the discovery was made of the body of Mr. Humphreys? What happened after that? After you make your call, what are your duties in reference to that?
Well, I secured the scene until the investigators could arrive and take over.
Okay, was anyone allowed to touch the body after you arrived and determined that the man was dead?
Only the paramedics who did make the determination that he was dead.
And that was in your presence?
Yes, it was.
Anything disturbed or moved or altered or in any way done to the body other than checking to see whether or not there was assistance that could be rendered to him by the paramedics?
No, sir.
And nothing else was done, he wasn't touched?
No, no.
How did you go about securing the scene?
I taped it off with evidence tape. I kept everyone outside of the area until the supervisor and the investigators arrived.
So let me show you, if I may approach your arm.
Yes, sir.
What has been marked as states ZZ for identification. I'll direct your attention, sir, solely to the top photograph and states ZZ for identification. Are you able to recognize that photograph?
Yes, I am.
Does that photograph fairly and accurately depict the body of Charles Humphreys as you saw it on September the 12th, 1990?
Yes, it does.
Do you recognize that as the individual that you found?
Yes, it is.
So let me show you what has been marked for identification purposes as states J for identification. I ask you if you can point out the location, or do you recognize where you found Charles Humphreys?
Right in this area here.
I'm sorry, would you point it out for me again?
Right about here.
Okay, and what is that? That is designated by, sir? The place of his body by what?
3A. Right there.
Okay.
Right between these two.
Okay, so right between 6 and 3A?
Yeah.
All right, for the purpose of our chart, sir, would it be fair to say that 6 would be a location where his body was found?
More than likely, it was on the north side of Marion Oaks, north side of...
Okay. I mean, I'm only asking an approximation. I realize it's difficult to place a dot on a map exactly.
Objection, Your Honor. If the witness can do the best he can without comment.
All right, sir. Okay, and if you'll review this chart, sir.
Okay.
Look at the chart and tell me if you can determine which of the numbers corresponds to where you found the body.
Let's see. 6.
Number 6?
Number 6.
All right, sir. So let me show you then what has been placed in evidence as states 42. And ask if you could point out for me, and I'm going to give you a sticker, the general location approximately where you found Mr. Humphrey's body on the 12th of September, 1990. Place that on there.
There.
Your Honor, objection has not been established. The identity has not been established.
Counsel didn't object, Judge.
Move to strike the comment and move for a curative instruction, Your Honor.
Both objections are overruled.
Thank you, sir. I have no further questions. No, one question. Where was the body located? What county?
In Marion County.
Thank you, sir.
To Marion. Them boys and girls found that body up in Marion this morning.
Good morning, officer.
Thank God
You
it's early.
indicated
I
that
like
you
this.
located this body in a subdivision, is that correct?
Yes, Marion Oaks.
And it's in a cul-de-sac?
It was at the end of a road. The road comes to a dead end if you're traveling westbound on 132nd, and it abuts a farm property. It stops at that point, and there's a stone culvert at the end.
Okay, thank you. No further questions.
Your Honor, may this witness be released?
You need a telephone number?
Subject to telephone number.
All right, sir, you may stand down at the card if you will give the telephone number where you may be contacted. You may get card. If you are in the rules, or it is not, but that's not.
Your Honor, to please the court, may the state at this time publish to the jury that item that is in evidence.
Yes, sir.
Thank you, Your Honor.
Next video, I'm interested to see how long it is. An hour? Yeah, let's do another hour here this morning. That'll probably top us off for the week here. Detective David Taylor is going to start us out. What else we got? Detective Ken Jones and latent print examiner Marvin Stevens. That's who we got right now in the stream the next hour, folks. Again, thanks everyone for hanging out. I appreciate it. One thing that this stream is going to do, it will take you out of this stream, which will be another hour. But in about an hour, when we do that, oh shit, hold on. This is going to take you into the stream that I'll be doing tonight on Wrestle Plunge, my second channel here on YouTube, where it's, you know, primarily a pro wrestling channel. And I know you're thinking, why the fuck do I care about that? I tell a lot of really weird stories that also oftentimes can be true crime-ish. A lot of mostly backstage real-ish stories. And yeah, please check out today's video. A new video also drops today at 4:45 Eastern. But yeah, a lot of cool stuff coming up in there. Let me, boom, here we go.
Taylor, and I'm an investigator with the Marion County Sheriff's Office in Ocala.
How long have you been employed in that capacity?
What's up, Caleb?
I've been with the Sheriff's Office for approximately 5.5 years.
Hope you had a good Thanksgiving.
And have you been a detective for a period of time?
Just almost 4 years.
Are you assigned to any specialized investigation case?
Yes, sir, I am. I'm assigned to the Major Crimes Unit, which is a division within the Criminal Investigations Division.
Did you become involved in investigation of a homicide in your county on September the 12th, 1990?
Yes, sir, I did.
Could you describe to the ladies and gentlemen of the jury how you first became involved, and where you responded to, and what you observed?
Okay, I was at my residence, and I'd received a telephone call from our communications center. It was late in the evening. It was on Wednesday, September the 12th of 1990. I was requested to respond to a scene in southwest Marion County, which is known as Marion Oaks, and it was around 9:30 or so that when I arrived at the scene.
So can you describe what you observed when you arrived at the scene?
Okay, initially when I arrived at the scene, my first contact was with a patrol deputy who was on the outside of a perimeter area. He directed me in as to where a location of a body had been discovered. I went into the area that was secured and made contact with the deputies who were at the scene securing the body.
Can you describe what your duties would be at that time when making the determination that there was a body found in Marion County?
Okay, initially, or once I arrived at the scene and I had located the body, it was my responsibility to initiate a preliminary investigation into the circumstances surrounding the death. I was able to examine the body once we were able to walk up to the body and find that the body was, or the person was in fact deceased.
Can you describe what that individual was wearing at the time? Was he clothed or unclothed?
He was clothed.
Could you determine from your visual observation, based upon your experience as a law enforcement officer, whether there were any gunshot wounds to him?
I was only able to see what appeared to be one gunshot wound, and it was in the upper left quadrant of the chest. It appeared to be just, a real small hole, and there appeared to be some powder residue around the wound.
Of course, permission to approach. Judge, approach.
Yes, sir.
Sir, let me show you what has been marked in evidence to say double Z for identification, the top photograph. Ask you if that's a fair and accurate representation of the person's body that you found on the 12th of September, 1990.
Yes, sir, it is.
Is that how he was clothed?
Yes, sir, that is correct.
Is that the condition of his body as far as the blood stains to his clothing that you were able to observe?
Yes, sir, that's correct.
Your Honor. Rephrase your question.
Did you observe anything about his clothing, sir?
Yes, sir, I did.
What did you observe, sir?
They were stained with blood, or what appeared to be blood.
Now, after making a determination that the individual is deceased, can you describe to the jury what steps you would take in your investigation right there at the scene? What do you do?
Okay, well, initially, we examined the body. We tried to establish some identity.
What would you do, Your Honor, as opposed to what the investigator did in this case?
What did you do that
Okay.
day upon finding Mr. Humphrey's body?
I tried to establish an identity to the person. We could not find any. The evidence technician was with me while we were examining the body. He was making videotapes and taking still photographs. Once the body was turned over, we were able to find a gunshot wound, or what appeared to be a gunshot wound. Then we just sealed everything as much as we could, and I notified a supervisor that we had a person that had appeared to have been, killed by a gun, and to notify him, and also that he was a John Doe at that time.
Okay, did there come a point in time in your investigation that night, or that day, excuse me, that you were able to make an identification of the individual who you found?
Yes, sir, I did.
How were you able to do that?
We had been supplied with information, our patrol division, by a teletype or a BOLA, what's called Be on the Lookout. The county south of us, which is Sumter County, Florida, had an individual who had been reported missing the previous day on the 11th. The physical information was pretty much the same. We contacted the Sumter County Sheriff's Office, and they sent 2 representatives from their agency along with a representative from HRS, who was a co-worker with the person who was missing.
And did that BOLA reflect the name?
Yes, sir, it did.
And whose name was that?
He was Charles Richard Humphreys.
Objection, hearsay, Your Honor.
Not offered for the truth of the matter, sir. All right, sir. Now, while on the scene, were you able to was there any identification made of the victim by any individuals that were known to Mr. Humphreys?
Yes, sir, it was. That is correct.
And can you explain to the jury how that occurred?
Once the 2 individuals from Sumter County arrived along with Mr. Jones from HRS, informed them what we had. They accompanied myself along with my supervisor to the location of the body. When the body had already been turned over, Mr. Ken Jones was able to positively identify the body of that of Charles Richard Humphreys.
Were you able to determine what relationship, if any, Mr. Jones was to Mr. Humphreys?
He was a co-worker at the HRS office in Sumterville, Florida.
Were you able to determine through your investigation what was the job description that Mr. Humphreys held with HRS?
Objection, Your Honor. Relevancy. Objection.
Objection, overruled. Go ahead.
Mr. Humphreys was a child protection team investigator, child protection worker.
Were you able to determine in the course of the investigation how long he had been employed with that agency?
He had not been there, but just
Answer the question if you can.
he had not been there, but just for a short period of time.
All right, sir. Were you able to determine from your investigation whether or not he had any prior law enforcement experience?
Objection, Your Honor.
Your Honor, I'll connect it up.
All right. Objection, overruled.
Yes, sir, I did.
And what were you able to determine during the course of your investigation as to his prior law enforcement experience?
Objection, Your Honor. Relevancy, state and federal grounds.
Objection, overruled.
He was a retired police chief from an agency in Alabama.
Were you able to determine his approximate age?
At the time that we found him, I believe he was in his 50s, just by my visual observations.
So let me show you what has been previously marked for identification purposes as states EEE for identification. I ask you if you'd open the pack and examine all the photographs therein. Sorry, Judge.
Go ahead.
Sir, in examining states EEE for identification, each of the 3 photos, first the one directly to your right hand, that individual reflected as, can you describe if that's the same individual that we see in the upper photograph that states ZZ for identification?
Yes, sir, this is Charles Richard Humphreys.
Also, sir, in the next photograph showing the individual once again, is that the same individual as you see in states ZZ for identification?
Yes, sir, it is.
Once again, Charles Richard Humphreys?
That is correct, yes, sir.
Okay, now you described to the jury that you saw a bloody shirt with a gunshot wound. Can you tell me whether or not that shirt is depicted in states EEE for identification? Third photograph.
Okay, this is the same shirt that Mr. Humphreys was wearing the night that he was, his body was discovered in our county.
As is reflected in states ZZ for identification?
That is correct, yes, sir.
Now, sir, during the course of your investigation, did you come into contact and obtain states KK for identification?
Yes, sir, I did.
All right, sir, and can you describe to the jury what states KK is?
This is a fingerprints, and I came in possession of these at the main HRS office in Gainesville, Florida. I was requested to go to Gainesville to obtain the known fingerprints of Mr. Humphreys.
Does the fingerprints card that you have before you establish or have a social security number?
Yes, sir, it does.
And what was that social security number?
The social security number is on this card is 365-329108.
And during the course of your investigation, did you come into contact with anything that corresponds relatively to the numbers of that social security card?
Yes, sir, I did.
Can you describe to the jury how that came? Can you describe what that item is?
Okay. I was at my house. It was on a weekend. I had received a telephone call from Sergeant Bruce Munster. He wanted me to go to our office in Ocala to locate the Social Security number of Mr. Humphreys. I went to our office in Ocala and I was able to retrieve that and provide that information to him.
Sir, now let me show you what has been marked that states Triple H for identification. And I'm going to ask you to open this up and tell me if you can identify this as the item you now play.
Good.
Break the evidence seal if you will, sir.
I am the king. Not baby.
You move that item, please.
Pulling out here, VCR. Nope, briefcase. Coat all over it.
Contained in states Triple H for identification, sir. Can you describe that item?
Okay, this is a briefcase. And
Covered in cocaine.
It's a briefcase that was collected and was placed into our evidence section at the Marion County Sheriff's Office.
Okay. During the course of the investigation, was it determined by your department that the first 6 digits of Mr. Humphrey's serial number worked to the combination locks of this briefcase?
That is correct.
Objection, Your Honor. Hearsay, basis of knowledge, opinion.
All right, sir. Would you please roll the
Yeah, thank you so much. I appreciate the $5, man. You're the best. Sending love to anyone having tough times. Worst month ever. Huge thank you to the community and Pastor Steve for the laughter and fun it brings. No, thank you, man. That's amazing. But yeah, everybody in the community that's having rough times, and I know that coming out of Thanksgiving and into Christmas, it is one of the roughest times for a lot of folks. You know, a lot of folks that maybe are getting older. It's a good time to check on neighbors, especially if they are older or elder as well. And I don't know. It's a tough time, man. So I'm happy that everyone can come in and still have a good time and have some laughter here. If you are in any kind of position to where maybe life isn't super fun, I mean, you gotta always find the laughter, man. That's the one thing I know to get through this son of a bitch. That's for sure.
What was that briefcase to try to
Thanks so much,
digits of Mr. Humphrey's Social Security number?
Objection, Your Honor. Hearsay, basis of knowledge.
Objection overruled. Go ahead.
The record reflects that the witness has rolled the tumblers, has now opened the briefcase from a flock position using the 6 digits of Mr. Humphrey's
Be rough, man.
Social Security. Could you read for the record the digits located and corresponding number?
Okay,
Objection,
reading
Your
from...
Honor. The predicate objection still stands.
Objection overruled.
May we have the running objection to all predicate issues in this trial?
Yes, sir.
Thank you, Judge.
Okay, reading from left to right, the numbers are 365, 329, which are the first 6 digits of his Social Security number.
Let me show you, sir, what has been marked for identification purposes. That states Triple C for identification, and ask you if you can recognize that photograph.
Yes, sir. This is a photograph of Charles Richard Humphreys.
Objection to it being published, Your Honor. Motion for mistrial.
Sustain the objection as to the publication. Motion for mistrial is denied.
David Taylor was the name of a British wrestler. Good one, too.
Sir, now in furthering your investigation, did you continue to seek out the individual who would have shot Mr. Humphreys when you... Well, what did you do next? Let's go into that. From the scene, you have the body. What is the next thing that's going to happen after you leave the scene?
Okay, once the investigation at the scene was completed, myself, along with Sergeant, I'm sorry, it was Captain Benninger, we had traveled to the Wildwood Police Station.
What was your purpose of traveling there?
The reason why we had traveled to the Wildwood Police Station was that, based upon the information we had received from the Sumter County deputies, was that Mr. Humphreys was in the city of Wildwood the day prior, and he was in a capacity of working on an investigation in the city of Wildwood, and that also that he had stopped by the Wildwood Police Department to speak with some of the officers that were there.
Let me ask you this, sir, going back to the scene, were you able to locate any motor vehicles belonging to Mr. Humphreys at that scene?
No, sir, I did not.
Were you able to locate any personal property of Mr. Humphreys at the time of your investigation when you found his body?
The only personal property was a pen and pencil set, some jewelry. There was no wallet.
His wallet was missing?
That is correct.
And was there any vehicle identified as being that of Mr. Humphreys?
The only information we had was from the report that was filed in Sumter County that Mr. Humphreys' vehicle, it was not with, the location of the body, and it was presumed to be missing at that time.
Did there come a point in time when you located Mr. Humphreys' motor vehicle?
Excuse me, I didn't hear the
Did
question.
there come a point in time when Mr. Humphreys' motor vehicle was located?
Yes, sir, that is correct.
Can you describe to the jury how that came about?
Okay, it was on, I believe it was on Monday, October the 15th. We had received a phone call the weekend prior to that Monday that a vehicle had been recovered in Suwannee County, which is up in the north part of the state of Florida. It was recovered by the Suwannee County Sheriff's Office. Myself and Sergeant Munster early that Monday morning traveled to Suwannee County and was able to locate Mr. Humphreys' vehicle and recover it.
In that vehicle, were you able to find any articles of personal property of Mr. Humphreys?
No, sir, I was not.
Now, let me show you, sir, what has been introduced in evidence. The state's 43, and ask you if you can identify that vehicle.
Yes, sir, this is Mr. Humphreys' vehicle.
Now, prior to your obtaining Mr. Humphreys' vehicle from the other law enforcement agencies, did you continue on in your investigation?
Yes, sir, I did.
Okay. And were you able to recover any items that became relevant to your investigation in determining the cause of death of Mr. Humphreys?
It's just information that was provided to me from the medical examiner's office that he had been shot to death.
Okay, and what, if anything, to do with that information that you had?
Okay, relating to?
Okay, did there come a point in time that you obtained any information or personal property of Mr. Humphreys from any location?
Yes, sir, I did.
Can you tell us when that occurred and how it came about?
That was on, I believe it was October the 13th. As you're going south from Ocala, you travel down towards southern Lake County. There was an area right on the Lake County, Polk County border. It was called Boggy Marsh Road. Initially, we had received a telephone call from the Ocoee Police Department stating that some property had been turned into them by an individual, and the property was a badge case, and it had the name of Mr. Humphreys in it. We met with the individual who had located that property on a Saturday. We met with him in Lake County. He drove us over to this area, which is called Boggy Marsh Road. He showed us a location where he recovered the wallet. Myself, Sergeant Munster,
Hey, you ever been up to Marion up there, boy? They got Boggy Marsh up there, boy. Shit. I'm going to jump in the truck, head up to Boggy Marsh, and get a couple. I might get a sixer. How about you meet me up there? We'll go fishing on Boggy Ridge up there, or Boggy Park. They got a little swamp out there.
From the Sumter County Sheriff's Office, we searched that area, and during the course of that search, we were able to recover certain property that did belong to Mr. Humphreys.
Can you describe the property that you found at that scene?
Okay, some of the items that were found at the scene, we found a bumper sticker that had been like wadded up and thrown over into the ground, or to the ground. We recovered a map of Lake County. Recovered certain identification cards like you would carry in your wallet, like a golf card, a couple International Association of Chief of Police cards that had Mr. Humphreys' name on that.
Did you recover any items adjacent to any of those articles that day?
Yes, sir, I did.
What, if anything, else did you find?
One of the items that we recovered was a spent .22 caliber casing.
So now let me take you back first to the bumper sticker.
Yes, sir.
Okay, what, if anything, was done in connection to the evidence gathering of that bumper sticker?
Okay. When the items that were located, they were photographed prior to us collecting them and putting them into a paper bag. Once all the items that were collected by us that day, they were carried back to our office where they were placed into an evidence section.
So So let me show you what it
See, they still have not given this lady a proper fucking desk.
marks for identification purposes. That states double B1 for identification. A series of 2 photographs. And states double B2 for identification. First as the states, triple B1 and triple B2 for identification. First as the triple B1. I ask you if you can recognize those photographs.
Yes, sir, I do.
Okay. Do those photographs fairly and accurately depict the scene of the bumper sticker on the top side photograph as when you found it on October the 13th of 1990?
That is correct, yes, sir.
Okay, and the photograph at the bottom, what does that reflect? Sir?
That is a yellow sticker. It's got blue or black writing. It says Florida Association of State Trooper.
Okay, is that in
decal.
fact the sticker once it was unwadded?
Yes, sir, that is correct.
Now, with that sticker in your possession, did there come a point in time where you tried to determine whether or not it would match anything about Mr. Humphrey's car?
I spoke with Mrs. Humphreys, and she informed me that there was, in fact, a Florida Association of State Trooper sticker on his car.
Sustaining objections to hearsay.
Did you physically do anything to try to determine whether or not that sticker would have matched a location on the car?
That we did when our vehicle was processed by our evidence technicians.
So your evidence technicians took the bumper sticker and they found a spot on it?
Your Honor.
Go ahead, objection overruled.
Do you know from your investigation what was done with the bumper sticker with your evidence technicians?
Okay, also there was process for fingerprints.
Number 1, process for fingerprints.
That is correct.
Okay. What else was done with it?
Hearsay, Your Honor.
If he has knowledge, he can answer. Go ahead.
What else was done with it?
That's, to my involvement, that's all I had with the evidence
All right,
sticker.
so
It was sent to be processed for fingerprints.
Process for fingerprints that you do. Okay. Now, if you look at state triple B2 for identification, under here. Can you tell me whether you can identify that item, sir? Now, the record reflects that the witness is now opening what has been previously marked as states triple B for identification, triple B2. Sealed manila evidence envelope. Thank you. All right, sir. Contained in states triple B2, is that the same fingerprint card that you read the Social Security from of Charles Richard Humphreys?
Yes, sir, it is.
When I say the same, that is an original inked roll print as opposed to a photographic copy.
That is correct, yes, sir.
Let me show you also, sir, what is marked for identification purposes as states triple F for identification. Let me show you first, I'm sorry, Your Honor. What has been marked as states triple A1 and triple A2, excuse me. I ask you if you recognize those photographs.
Yes, sir, I do.
Do those photographs fairly and accurately depict the scene of what you observed on October the 13th when you recovered the spent casing?
That is correct, yes, sir.
Okay. Now, can you describe, without publication to the jury at this time, what states triple... Turn on here. Let me do it for you. States triple A2 represents and how it differs at all with states triple A1 and why it differs, if you know.
Okay, during our processing of the scene when we were down in Southern Lake County, we recovered, like I said, a spent .22 caliber casing. When we recovered that, I took a photograph of the casing prior to it being collected and placed into a prepper bag. And also, before I took possession of it, I laid down a quarter as a means, for measurement and to show the size of the casing and stuff. There was a photograph taken of that also.
Okay, and were you present when that photograph was taken?
Yes, sir, I was.
You the one who placed the quarter down there?
That is correct.
Let me show you, sir, what has been marked as states triple F for identification. I ask you, without opening the container, can you tell us if you recognize it?
Okay, yes, I do.
How do you recognize that, sir?
On the upper right-hand corner is the case number S90248811 with the date of 10/13 of 1990, and it has my initials, DDT.
And can you tell, ladies and gentlemen of the jury, what item you placed within the bag that is marked states FFF for identification?
This was the spent .22 caliber casing shell that I recovered.
Is that the shell that is represented in states AAA1 and AAA2?
That is correct, yes, sir.
And that was found in relationship to the bumper sticker that you indicated was processed for fingerprints?
That is correct.
Approximately how far away from Mr. Humphrey's body were those items found?
It was, I'm not sure of the mileage, but I would say probably 40, 50 miles south of his body.
Judge, may I have one moment?
Yes, sir.
Your Honor, please, the court, at this time, the state would offer in evidence states B1 for identification purposes as evidence. States AAA1 and 2. States C.
Oh man, she don't stop talking, does she?
States K.
You're like, I'm getting fucked here. Do something. It's like, we're trying. She's pissed, dude. Look at her. Not happy. Your hair's completely different than last time.
Report by
That's
counsel
the
through that.
huge fucking...
Let me show you so as the mark states L for this. L for identification. I ask you if you can recognize that bag.
Yes, sir, I can.
If so, how do you recognize it?
On the outside of this bag is once again the case number of our case, which is S90248811, the date of 10/13 of 90, and my initials are right below that, DDT.
So would you open that up for us? Now, the record reflects that the witness is unsealing the bag by cutting it, which was previously sealed with evidence tape. Sir, can you describe for the ladies and gentlemen of the jury what was contained within states L for identification?
This is a yellow sticker with dark blue writing. It says Florida Association of State Troopers. It's a decal.
Is that the bumper sticker that you found, which is represented in the photograph of states 44, which is now in evidence?
Yes, sir, that is correct.
Wadded up in the top?
Yes, sir, that's correct.
Opened up on the bottom?
That is correct.
State would offer states L for identification, Your Honor.
We'll give you opportunity to observe and watch it.
You folks have any objection to any of the other objects that are inside?
Look at how
the
much
bag?
fucking paperwork is on that desk.
No
Holy
objection
cow.
to anything on the back.
That'll be received in March.
Jeez.
This time, Your Honor, the state would also offer for evidentiary purposes states FFF for identification.
We'd like to inspect, Your Honor.
Yes, indeed.
All right, Your Honor, would it be necessary then to open up the bag for court permission?
Let the parties examine it.
And the record reflect that the witness is going to open will you open the bag, sir, at this time? And the record reflect that he's opening a sealed evidence bag. States FFF for identification. Leave the top on. Thank you.
The
this the spent casing that you recovered as described to the jury today?
Objection, Your Honor.
Rephrase the question.
Can you describe to the jury what this object is?
This is a spent .22 caliber shell casing.
Where did you find that casing?
This is recovered in Southern Lake County off of Boggy Marsh Road.
Is that item reflected in the photographs that are now introduced in evidence as states 47 and 46?
That is correct, yes, sir.
And you recovered this item?
Yes, sir.
Offer it, Your Honor.
Yeah.
No objection.
With the evidence being received and marking that on that proper number.
Just checked over on the old Cash App. Well, I checked my email and it came through my Cash App. Tiffany. Tiff Knox coming through for Sunday morning church. Thank you. I appreciate that. $5. Tiff getting on that thing. And I think Tiff wants one of these brand new Savage stickers, which has got the dope ass canvas texture. And that's the way to do it right there as we build a wheel. Build a wheel, brothers and sisters, this morning in the church. Thank y'all so much for hanging out. Appreciate it.
The court of state will offer states double Z for identification purposes. That states evidence at this time.
Counsel, hearing down this
Just
item.
hard. What's that, Judge? We got Judge Turd. Oh God, it's a paper war!
Is there objection?
There is your.
There is the objection is sustained.
Your Honor.
Item number ZZ will not be recommended.
Thank you, Your Honor. May these items that have been introduced in evidence be published to the jury at this time, Your Honor?
Yes, you want in the evidence. Give the clerk ZZ.
Now, still hold on to that. Court's permission?
Yes, sir.
All right, Miller. Court permission, Judge, I'm going to start with the first alternate juror, the right-hand side, go to the back row, the left-hand side, and begin distributing. Excuse me, an exhibit as states double Z for identification, the top photograph.
Yes, sir.
Can you describe for them the condition of his pants pocket?
The left front pants pocket was turned inside out.
Objection, relevance, Your Honor.
Objection overruled.
And did you find any items of significant value on him at that time?
Objection, Your Honor. Vagueness.
Overruled.
It was just, like I said, the pen and pencil set. I believe there was a wedding band, a watch, and there was some change in the other pocket, I believe.
Find any hard currency?
No, sir, I did not.
Dollars?
No, sir.
Paper currency?
It was just coins.
Just some coins left in his pocket.
That is correct.
That pocket hadn't been turned out.
That was on the right pocket.
So only one pocket had been turned out.
That was the left pocket that was turned inside out.
There was nothing contained in the crevices or cracks in that pocket of bag, is that correct?
No.
Now, when you recovered Mr. Humphrey's motor vehicle, do you know whether or not you were ever, during the course of your investigation, able to find any fingerprints on that motor vehicle or in it?
The vehicle was processed, like I said, by our evidence technicians. They were assisted by the Citrus County evidence technicians. I was not present for that.
During the course of your investigation, have you learned of any fingerprints of identifiable value being found in that motor vehicle?
Objection. Calls for a hearsay, Your Honor. It's not matters within his personal knowledge. He's already said that.
Sustain the objection as to that.
You mentioned a badge case was found that was identified as being Mr. Humphrey's.
That is correct, yes,
Did you ever
sir.
find the badge?
No, sir, I did not.
So this was an empty badge case, is that correct?
That is correct.
Objection overruled.
That badge case was found approximately in what location in relationship to the fire casing?
Well, the badge case was found by the individual who had turned the item over to his wife, who gave it to the Ocoee Police Department. It was within the same general vicinity.
Where you were taken by him to where you found it?
That is correct. He said everything was right in that area, right between the little service road, and there was a pond there.
Thank you very much. I have no further questions for witnesses at this time.
Any inquire?
Thank you, Mark. Good morning, officer.
Good morning.
You indicated to the prosecutor on direct examination that 2 individuals from Sumter County came to Marion County to give you some information about this case in conjunction with a Mr. Jones.
Okay. The night that we located the body in Marion Oaks, like I said, we were in possession of information that come across the radio and through a BOLO bulletin as to where an individual had been reported missing. Our office contacted their office. They sent 2 representatives from their agency to us. Also with them was Mr. Jones.
Okay, can you give me the names of the 2 individuals from Sumter County that accompanied Mr. Jones, please?
Off the top of my head, the name slipped my mind right now, but it was the chief deputy, I want to say Matthews, and Jim Fussell, I believe.
Okay. When you went to the scene where Mr. Humphrey's body was discovered, you indicated that you viewed the body, is that correct?
That is correct, yes, ma'am.
And Mr. Humphreys was wearing a watch, wasn't he?
Yes, ma'am.
And he was wearing a yellow gold ring, wasn't he?
It was a ring.
It was a wedding band, wasn't it?
Yes, ma'am.
And there was a pen and pencil set that he had in his pocket, isn't that true?
In his shirt pocket, correct.
And that was a cross pen and pencil
Yes,
set,
ma'am.
wasn't it? You indicated that Mr. Humphreys was last seen in Wildwood. He was last seen at a motel in Wildwood, was he not?
Our investigation revealed, as far as I could determine, that's where he was last seen.
And in fact, you had evidence that he had purchased beer at the Wildwood's place where he was last seen.
That information was developed by Sergeant Munster.
Okay. Sergeant Munster became the lead investigator in that case, didn't he?
That is correct.
Okay. And eventually got involved in book and movie rights, is that correct?
Objection, Your Honor. Move to strike improper.
Take the objection.
I ask the counsel be admonished, Your Honor.
Go ahead.
Thank you, Judge. Did you find any other personal belongings on Mr. Humphreys in terms of jewelry or anything of that nature?
Just what was recovered, like the watch, pen and pencil set, the ring, and there was some change that was in his pocket.
Some change, and that is all that you found?
All that was with his body when we recovered the body.
Okay. One moment. No further questions. Thank you, Your Honor.
Just briefly, Your Honor.
Yes, indeed.
Sir, when you found Mr. Humphreys, was he fully clothed?
Yes, sir, he was.
Let me show you, sir, Manfield marking for identification purposes. State's deposit exhibit.
Counsel, you view the items here.
Pitting ain't easy. That might be a fun shirt. Pimping ain't easy. Pitting ain't easy. Yeah, no one likes him at all. He's very wild.
He's just marking for identification so far.
Good, thanks everyone for hanging out. As the court gets its shit together.
Sir, let me show you what has been marked for identification. Once again, it states double Z for identification. Is that the condition that you found Mr. Humphrey's clothing in when you arrived at the scene, as is depicted in states, double Z for identification, the top
Yes.
photograph of this composite exhibit.
Yes, sir, it is.
Let me show you as the marker states triple M1 for identification. I ask you if that's a fair and accurate description and representation of the condition of the clothing when you observed it at the scene in relationship to the man's pants, belt, and zipper.
Yes, that is correct.
Okay. When you came upon the scene, did you view the condition of Mr. Humphrey's pants as to the belt, the zipper, and the closure of his pants?
Yes, sir, I did.
Were those pants on and fully closed, or were they off in any way?
They were on.
Was there any item upon him that was not on? His shoes, his socks, anything of that nature?
He was wearing his shoes, his socks.
Let me show you what's been marked. It states triple M2 for identification. Are those the shoes and the socks that you're describing to the jury that you
Beyond the
found?
scope of cross, Your Honor.
Next number, go ahead.
Yes, sir.
And let me show you what has been marked. It states triple M3 for identification. Once again, can you recognize that photograph as a fair and accurate representation of the condition of Mr. Humphrey's clothing
Yes, sir, I do.
when you first observed it at the scene, with the exception that it has now been moved to the medical morgue?
That is correct, yes, sir.
Sir, can you tell the jury approximately how far off the roadway Mr. Humphrey's body was found?
Well, the main road that travels through that area as to where he was located is County Road 484. The area was an undeveloped subdivision. I would venture to say approximately 2/10 to 3/10 of a mile north of the main county road, which is 484 that runs through that subdivision.
Would an individual who was out in that field where you found that body be able to be seen from some distance? Can you tell us, from your knowledge of that area, the visibility from the location where Mr. Humphrey's body was found to the roadway and other adjacent areas?
Okay, to the main highway, which is 484, there's a crest of a hill, and you would not be able to see County Road 484 from where his body was discovered. Where we discovered his body is at the end of like a cul-de-sac, which was a paved street. People drive back in there all the time.
You know that of personal knowledge that people come in and out of there.
Well, I've been back in there myself several times.
Not the kind of place where you want to have a body left to be
Objection leading, Your Honor. Motion to strike, motion for mistrial, motion for admonishment of counsel.
Another mistrial.
I don't think so. Thank you.
You can answer that question, sir. That's not the kind of...
No.
Judge is like,
Okay, I will...
Motion for mistrial on the latter are denied. Motion to, the objection is sustained, don't answer.
Thank you. Nothing further, Your Honor.
clears them up.
You get the AC recross.
I don't think so, Your Honor.
You'll get those items that you have for notification back to the clerk on your way. You may have no further obligation for them.
Thank you.
Yes, sir. Council want the telephone number?
Yes, Judge.
Leave the number where you can be.
State your name, please.
Ken Jones,
Mr. Jones, where do you reside?
in Sumter County.
And what is your occupation, please?
I work for HRS.
How long have you worked for HRS and what do you do for them?
I've worked for them for approximately 8 years as a protective investigator.
All right, sir. Did you know an individual by the name of Charles Richard Humphreys?
Yes, sir.
And what did you call him?
I call him Dick.
Hey, that's old Dick.
Jury, please, what your relationship was with Mr. Humphreys and what he did for a living.
He was my supervisor for
Old Dick and Ken, man, they used to run all over this fucker.
approximately 2 years.
He was also worked for HRS.
Yes, sir.
In what particular division were you and he working?
In, child,
Objection, relevancy, Your Honor.
Objection overruled.
Yes, your name.
child abuse investigations.
All right, sir. When is the last time you saw Mr. Humphreys alive?
Yeah, they did. They left the Coke suitcase on there on the stand here.
On September the 11th, 1990.
When did you next see him?
September the 12th of 1990.
And where was he?
He was deceased. It was in a field.
You know your approximate location of the field to the jury?
It was in Marion County, off of County Road. I believe it was State Road 484.
Thank you. Your Honor, may I approach the witness?
Yes, sir.
I ask you to look at State's Exhibit 45 and ask if you can identify the individual whose picture appears there.
Yes, sir. It was my supervisor, Dick Humphreys.
Thanks, Your Honor.
further questions, Your Honor.
You may inquire.
No question, Your Honor. Thank you, Mr. Chairman.
You may stand down, you're discharged, you have no further obligation to the court. You are under the rule of that if you're not to discuss the testimony on the case.
That was great.
Thank you, sir.
Call your witness, please.
State will call Marv Stevens, Your Honor. Sir, would you please tell us your full name and your place of employment?
My name is Marvin Lee Stevens. I am employed with the Florida Department of Law Enforcement.
In what capacity are you still employed, sir?
I'm a crime laboratory analyst assigned to the latent print section.
How long have you been employed with the Florida Department of Law Enforcement?
Next month will be 14 years.
And during that 14-year employment with them, have you been involved in the identification of latent and inked fingerprints?
Yes, sir, I have.
Could you tell the ladies and gentlemen of the jury some of your experience in fingerprint identification, palm print, latent, roll?
My fingerprint training, or information about fingerprints, started in June of 1976 with the FBI in Washington, D.C. I was a fingerprint technician, and I was involved in a training class for 3 months entitled The Science of Fingerprints. In this training class, I went through all aspects of inked fingerprints. This would be the classification, the filing, and more importantly, the identification of inked fingerprints. Upon leaving the FBI in '77, I then became employed in 1978 with the Florida Department of Law Enforcement in Tallahassee. I worked in the inked fingerprint section for approximately 7 years, going up all the way to a inked fingerprint supervisor. And then in October of '84, I was then promoted to the crime laboratory system. I went through a 1-year training program of all aspects of latent fingerprint work. And at the end of 1 year, I went before a board of my peers, and then I was found to be knowledgeable of latent fingerprints, palm prints, and then I was an analyst in November of '85.
All right, sir. Could you tell ladies and gentlemen of the jury about approximately how many occasions have you been called upon to examine latent fingerprints with known or rolled impression fingerprints?
How many cases?
Well, let's go cases, because I think if I asked you just all, we're going to get up into many thousands.
Approximately in a year's time, I will work between 225 to maybe 250 cases per year.
Can you tell us whether or not you've ever been qualified as an expert witness in a court of law in fingerprint and or palm print identification?
I've been an expert witness 28 times prior to today.
And you testified in the felony courts and circuit courts of Volusia County also?
I've never testified in Volusia County, no, sir.
Where do you primarily come out of? Which laboratory are you associated with?
The Tallahassee Laboratory, which is mainly the 2nd and 3rd Judicial Circuit in Florida.
Okay, would that be the location where you have been qualified as an expert witness?
Yes, sir.
Now, can you tell us a little bit about the difference between well, let me strike that if I may. Your Honor, I think in light of prior testimony, the jury has heard testimony on that matter. I will offer Mr. Stevens as an expert in fingerprint identification.
May we move on there, Your Honor?
Yes, sir.
Mr. Stevens, how are you, sir?
I'm fine, thank
Do
you.
you need those items of evidence that are right in front of you there for your testimony?
I may.
Okay. You going to testify about them?
Well, Judge, he wants a voir dire. If he wants a voir dire, then let's ask him about his expertise.
I'm going to go ahead and get it all over with now, and then we can get to lunch.
Yes, Judge. Do you have any graduate school training in fingerprint identification?
No, sir, I do not.
And your expertise is based on your experience, is it not?
That is correct.
No objection to the witness testifying as an expert, Your Honor.
You may proceed.
Yes, Your Honor.
Your Honor, I object to the comment, move for a mistrial, move for you to admonish counsel.
Move for mistrial is denied. Clean it up, counsel.
Yes, sir. Mr. Stevens, if you become involved in an investigation,
You're not ever getting
in which
this
you
mistrial,
examine
dude.
certain items of evidence purporting to be the fingerprint of a Charles Dick Humphreys.
Yes, sir, I did.
Ooh.
Let me show you what has been previously introduced in evidence. It states 49 in evidence. And let me also show you what has been marked as an exhibit, states triple B2 for identifications, which has been opened in open court by the previous witnesses. And if you'll please examine stage triple B2 for identification, you tell me whether or not you're able to.
This is triple B2?
Yes, sir.
And this is
Number 49 in evidence. Been opened at the top, sir, in open court. Let me also show you now in evidence of stage 48 in evidence. Asked if you recognize that document. Will you need a pair of scissors, sir?
Yes, sir, probably will.
May I approach you? Yes, sir. Your Honor, may the record reflect that the witness is opening up manila envelopes that were contained within stage triple B2 for identification.
Immediately following this, I will send you into a stream for tonight. Really appreciate if you hit like on that when you get there. It's my second channel stream tonight at 6 Eastern.
Yes, sir, I recognize all these items.
All right, so can you explain to the jury how you recognize stage 48 in evidence? I'm sorry, Madam Clerk, I'm having a problem finding it. Sorry, Judge. I'm sorry, a lot of paperwork they good. I'm holding a fingerprint chart that was within stage triple B2 for identification. Is that correct?
Yes, sir.
Okay, I just want to make sure I have everything where it was removed from. You recognize stage 49 in evidence, stage 48 in evidence,
yes,
and all of the items contained in stage triple B2 for identification. Is that correct?
that is correct.
Could you tell, ladies and gentlemen of the jury, what you did with those objects in attempting to make a determination as to who would have come into contact with states? Forgive me, I'm sorry, Judge.
All right.
49 in evidence, the Florida Association bumper sticker.
In receiving these items, first thing I would do, for example, the latent lift, this is known as the latent lift. These are photographs of latents that have been developed on an item. First thing I would do would be to examine them to see if they're of quality for identification purposes. If that would be so, then I would go ahead and have them photographed for preservation. And then once a standard rolled fingerprints of an individual submitted to me, then I will try to do a comparison to see if the prints on the latent lifts are then the same as from the inked fingerprint card.
And did you do that in this case, sir?
Yes, sir, I did.
Explain to the ladies and gentlemen of the jury how you go about making a comparison of a known ink source to a latent impression.
Looking on standard,
It's up too late.
Objection overruled.
looking on a standard ink fingerprint card, numbers are arranged from 1 through 10. This is meaning that the right thumb of an individual would go in the number 1 block, the index finger number 2, and so forth. On an ink fingerprint card, they have what is known as friction ridges. On the bottom side or underside of an individual's fingers, palms of their hands, even the soles of the feet, you have raised portion of skin. This skin, once you have a smooth surface, applied black ink, you have taken an individual's finger and roll the finger, and then transferred it to a fingerprint card or else to like a white sheet of paper for the best contrast from black ink to white. You'll note, or there is noted on here, Galton details. These are ending ridges. It is the most common friction ridge characteristics that are used. Also, next common would be known as a friction ridge bifurcation. Bifurcation is when you have one friction ridge and it will split or diverge. The point that it splits is another part of identification. And the third part I will use will be a friction ridge dot. And a dot is simply a friction ridge that contains at least one sweat pore. Looking at unique ridge characteristics found on an ink fingerprint and then comparing them to a latent fingerprint that has been processed else out in the field or else maybe in my laboratory myself. Then taking the latent fingerprint, and like I say, if it's of a quality, I will then have a photograph made of it, and then comparing it finger by finger, ridge characteristic to ridge characteristic, finding enough unique ridge characteristics, then I can make a conclusion and say the latent fingerprint that was developed on any item would be positively identified back to the person that had their fingerprints taken on the standard fingerprint card.
Now, can you identify on the standard fingerprint card that you are speaking about whose name is contained therein?
On this fingerprint card, the last name is Humphreys, first name is Charles, middle name is Richard.
And did you use this in your comparison with the latent fingerprints that were submitted to you?
Yes, sir, I did.
Now, sir, did you arrive at a conclusion based upon your examination of the known fingerprints of Charles Humphreys and that of the latent fingerprints submitted to you?
Yes, sir, I did.
And that latent fingerprint was contained initially before lifting from States 49 and evidence the bumper sticker.
That is true.
Did you arrive at a conclusion, sir?
Yes, sir. On Exhibit 8A, which is a negative, this negative, which was a photograph from this bumper sticker, contained enough unique ridge characteristics that I could claim the fingerprint, the latent fingerprint, as of value for identification purposes. The fingerprint that is on this negative was then compared, and it belonged to the right middle finger, or the number 3 finger in the fingerprint block, belonging to Charles Richard Humphreys.
Could two people have the same fingerprints, sir? Objection, Your Honor. Within your expert opinion.
That's not a rule.
The uniqueness of an individual's fingerprints are unique only to that person and nobody else in the world.
Can you tell us how you arrived at your conclusion, sir?
By comparing the unique ridge characteristics, again, like I said, they were found and contained on the negative taken from the bumper sticker, comparing the friction ridges, as I mentioned before, the ending ridges, the bifurcations, and the dots contained in the ink fingerprints were also present in the latent fingerprint on the bumper sticker. Comparing these, looking for uniqueness together, there were enough of the unique points there. Then I came to my conclusion they were made by one and the same individual.
Made by Charles Humphreys.
That is correct.
And sir, you used the term in describing latent fingerprints. I think it was of value, as you were describing. Can you explain to the ladies and gentlemen of the jury how a fingerprint might be left on a surface and how it might not be left, or how it would not also be subject to identification, even if there was some type of ridge characteristics or points that could be seen?
A latent fingerprint of value to me is at least 8 unique ridge characteristics that I can see in that print. A reason why an individual will leave a latent print of value or not of value is really 3 different reasons. One is the individual themselves. If a person's skin is real dry and clammy, or maybe also from their occupation, example I use a lot of times is people that are bricklayers. If their hands are real rough, chances of them touching something, handling something, or picking something up is not a good indication they will leave good, valuable, latent prints of value. Secondly is the item itself. If the item is nice and smooth, then that's a good surface for leaving a latent print. If the item is something rough or pitted, there again, it won't be a good surface for leaving latent prints. Now, the third condition of why you will not have a latent print is the atmospheric conditions. And once something has been touched and is left out in the elements over a period of time, you will lose your latent print due to weather.
Now, in this particular instance, the lift that you've been referring to is obtained from the sticky surface of the bumper sticker. Is that not correct?
That is correct.
All right, and as far as other lists of identifiable values, say on the other side of the bumper sticker, were you able to find any there?
No, sir.
So, if I understand your testimony, then elements, if an object is left out in the elements.
Objection to the rephrasing, Your Honor.
Objection overruled. Would it be correct to say that the ridge characteristics that would make you have the ability to lift a latent fingerprint would be dissipated, potentially?
It would diminish over a period of time, yes, sir.
Can you touch an object and not leave a latent fingerprint, even if it might be subject, the type that, like a piece of glass?
That is true.
Now, let's say I was to touch a piece of glass right now and move my hand across it, could you describe what type of impression, if any, I might leave?
If you had a glass surface, you may leave a streak or a smear across. Sometimes at the beginning of a streak, you can have a unique ridge characteristics that you could identify, or the end of where the finger was left off. But through the streak motion, usually you will not be able to have a latent print of value.
So just because someone touches an object doesn't necessarily mean that you're going to be able to lift a fingerprint from it.
That is correct.
This time, Your Honor, the state would offer states triple B2 for identification and contents therein as state's evidence. We'd also offer your own.
Yes, sir. If I can. Judge, can I kind of put them together with paper clips so they don't fall apart?
What's the defense?
No objection, Your Honor.
Let the item be received and marked. Show the evidence by proper number. You have further questions?
No further.
You may inquire.
Yes, Your Honor. Mr. Stevens, did you prepare any reports?
Yes, sir, I did.
You have them with you today?
Yes, sir, I have my
Can I
copies.
see your report relevant to the Humphreys case? And while you're doing that, let me ask you, these things here, the suitcase and all this, you did not need this, did you?
I don't need it.
Okay, let me get it out of your way.
The Coke case.
How about this bag? You need this, right?
Not unless you need me to identify it for something.
You don't mind if I take a look at it?
Counsel, can you tell me what date you're referring to?
Date of the report?
Yes, sir.
The report dated 5 March 1991.
It's gonna be on it.
Where did you receive the items that you examined in this case? From whom did you receive?
These items I had received from our evidence section in Tallahassee lab. You want the individuals' names or?
Yeah.
Okay. Chris Henry, Kathy Taft, Doug Freeman,
And it indicates that, and it's relevant to the Humphreys case. The printout relates to the Humphreys case.
yes, sir.
And 2 individuals are listed on that printout, are they not? two names that appear there?
Yes, sir.
Whose names are those two?
You're talking about the two type names?
Yeah.
Okay. First one is Moore, Teria, and the other one is Wuornos, Aileen C.
In your report, you indicated that there were certain additional fingerprints that were provided for you to do a comparison of, in addition to Mr. Humphrey's, did you not?
In Mr. Humphrey's case?
Yeah, in Mr. Humphrey's case. You got some other fingerprints other than Mr. Humphrey's.
Good. I'm sorry.
In other related cases, yes. In Mr. Humphrey's case is the only person I compared other than Tyra Moore and Aileen Wuornos.
Okay, so you compared Mr. Humphrey's prints and you also compared Ms. Moore's prints
That's correct.
and Ms. Wuornos' prints.
That is correct.
In the computer-generated printout and in the report that you prepared referring to Tyria Moore, do you know why those prints were given to you to compare in reference to this case?
No, sir, I do not. Just they were given to me to do a comparison.
Did the law enforcement officers tell you why they gave you Mr. Humphrey's prints to compare?
Only for elimination purposes, I think.
Did they tell you that Ms. Moore's prints were given to you for elimination purposes?
No, sir, it did not.
What is an elimination purpose?
Basically, elimination prints are inked fingerprints of an individual that either has access to an item or a place or a being that their fingerprints, if found, fingerprints or palm prints, that if they are found, they have a legitimate reason for their prints to be there, to be eliminated.
And so an elimination print is when you're checking to see if somebody who's supposed to be there was there.
Yes, sir. That's basically true.
Other prints are given to you to check whether somebody who's not supposed to be there was there.
Yes, sir, that too.
And one of the prints that was given to you in that regard was Tyria Moore, was it not?
Objection. He has no, this means, never mind, that was wrong.
Can you just repeat the question, please?
One of the prints that you got that was not given to you for an elimination print purpose was Tyria Moore's in this case.
That is true.
That was given to you by law enforcement officers.
That is true.
Nothing further.
Sir, did you find any prints of Ty Moore in reference to the Humphreys investigation?
Where, Your Honor?
On the bumper sticker, sir.
On the bumper sticker? No, sir. No prints of Tyra Moore on the bumper sticker.
Nothing further, thank you, Your Honor.
Stipulated that there were no more prints on the bumper sticker.
Your Honor, that's not what the witness testified.
If you can answer that.
So, Judge, we leave it as it stands, very short.
Anything further?
No, Your Honor.
Judge, we'll stipulate to it.
All right, so they keep the witness may be excused.
Yes, Your Honor, thank you. Subject to further recall.
I think the witness will be recalled at some
All
point.
right, you may stand down. Y'all have a way you can contact me.
Yes, sir. All right.
Where you are, we will certainly not discuss that where the case is considered.
Where we going next week? Starting next Sunday morning, we will be with, starting out with a 52-minute video, investigator John Tilley, CSI Fred Johnson, and firearms expert Donald Champagne. I feel like we've seen him previously, so it looks like we do get some recalls here. Great morning here in Murder Church. I appreciate everyone that came through. Appreciate the hell out of it, guys. We've got a wheel in the works. We'll continue that for sure on Tuesday. I'll be back here Tuesday night at 8 with some body cam, some dash cam footage, of course, and then book club immediately following as we're going into Chapter 4 of Mindhunter. Thanks everyone that came through here. Chris, it was awesome. Chris in the chat all morning, man, dropping some knowledge, some craziness. This one is very interesting. You know, I could see that it looks like that the prosecutor and the judge are incredibly biased. I mean, of course the prosecutor is, but the judge in general himself seems to be mostly on their side. Any kind of like objection that we get from the defense is always overruled. But also, I mean, I can see just when we had the one prosecutor reading out Aileen Wuornos' own words when she's talking about these murders and how she talks about these murders is, you know, it's pretty brutal. It's pretty crazy. And again, you know, you have to believe the fact that she was in this same situation, which I know she is. She was She was a hooker in Florida during this time frame. So, like, you know, I know she's going to be putting herself in a lot of vicarious situations, but at the same time, you know, you'd have to believe that this happened over and over. Like, how many people did she kill here? So I don't know. It's a crazy one. It's interesting. It's fun to watch though. But yeah, the judge is brutal. I don't really like her defense team. The lady seems all right. I don't like the dude that we just saw there. The main prosecutor that we see mostly is a douchebag, and like Chris was saying, they both seem like some douchebags. But one thing, please, today on the second channel, Wrestle Plunge, 4:45 Eastern, brand new video drops. Members of Wrestle Plunge already got the video as of Wednesday, before Thanksgiving even. But today it drops for the public. Please go give that a like. Anybody in the Buzz Nation that I see your comment, that allows me to put you on a list, on a wheel for a possible new shirt. And let me show you the brand new shirt over here on publiclybuzz.com. A brand new shirt, folks. Boom, right there, right on the nipple. Publicly Buzz logo, and on the back, Buzzed Pit Crew. Yes, we got a Pit Crew shirt, and you can have this thing for free. Again, all you have to do is go to my brand new video the day it drops at 4:45. Make sure you're also subbed up on Wrestle Plunge, and leave a comment, leave a like, and watch the video in completion. Helps me out greatly. And then tonight at 6 Eastern, I'm going to be live on that channel watching some classic wrestling from 1990. We have a lot of fun. A lot of people from the Buzz Nation comes over and hangs out. There's a lot of other new folks over there as well. And yeah, I appreciate it. I'd love to see you in the chat. This stream is going to take you directly into that one. So when you get there, please leave a like, and that would also help me out. So 4:45, that's right, Jay. Be ready. Be ready. Be ready for be ready for it. That's right. Be ready for it. That's right. Be ready for it. Let me put the link in here also. Yeah, go ahead. Go get yourself. These are flying off the I think she put the link in there, actually. Yeah, it's right there. Either way, these are flying off the shelves. Everyone's picking these up. I think I'm going to be getting one myself. J Money also credit for coming up with the idea of the Buzz Crew Pit Crew shirt. So come through tonight, folks. Great morning. Have a great week. Let's go. Love you guys.